My name's Alan Steinbrecher, and I am the chair of the State Bar Board of Trustees. Mr. McLeod, are we recording yet?
Yes, we are, and I'm going to turn the staffing reins over to the Secretary of the Board, Ms. Sarah Cohen.
Thank you. All right, we are session for the duly noticed meeting of the Board of Trustees for July 16, 2020. Again, I'm Alan Steinbrecher, chair of the board. Welcome, everyone. As a reminder, since we are being recorded, if you do choose to speak, please speak into your microphone clearly and identify yourself by name so that we have a clear record. The meeting is now underway at 9:52 a.m. And Ms. Cohen, will you please call the roll?
Broughton. Chen. Here. Cisneros.
Here.
Dela Cruz. Dellin. Duran.
Present.
Iglesias.
Here.
LeBron.
Yes.
Manning.
Here.
Pertula.
Here.
Selig.
Here.
Stallings.
Here.
Chair, you have a quorum.
Thank you. The first item on the agenda is an opportunity for public comment. And do we have any member of the public who would like to speak? Mr. McLeod will now give us the procedures for speaking if you are interested in doing so. Mr. McLeod.
Thank you, Chair Steinbrecher. It appears that most people know how to indicate that they're interested in giving public comments. I see a number of hands raised. It appears that there are fewer than 10 hands raised, which will allow the board to hear 3 minutes per person who speaks. I would like to go out of order, what appears to be out of order, because Mr. Harrison raised his hand and I believe is representing the Council on Access and Fairness. And so I'd like to offer the floor to him first. Mr. Harrison, when the microphone icon appears, you can enable it, and at that point you'll have 3 minutes to make your comments. Thank you very much.
Good morning, members of the board. Chair, my name is Ryan Harrison. I am a member of the Council on Access and Fairness, and a retired Judge Brenda Harbin-Forte, who's the chair, asked me to deliver remarks on behalf of COAF to you all. I'm going to go ahead and read her remarks to you. I've also provided them in writing through DAG earlier this morning. And here they go. My comments are made on behalf of retired Judge Brenda Harbin-Forte, chair of the State Bar's Council on Access and Fairness, relating to agenda item 701 on racial disparities in the discipline system. COAF is concerned that there are systemic, procedural, and structural deficiencies in the entire discipline system that lead to the unconscionable rates of disproportionate discipline of African-American males. COAF is concerned that implicit bias factors lead to this outcome. The recommendations in the report before the board today should all be implemented, but COAF believes the issues addressed in the report are just the tip of the iceberg. Also, there is too much built-in delay. Some changes can be implemented immediately and without further study. For example, the board could decide to implement immediately a rule that the threshold for RA bank inquiries should be $500 overdrafts in the trust account before the bank reports the potential ground for discipline. COAF urges the board to take 3 actions today. First, to appoint a task force to evaluate every aspect of the discipline system and make recommendations for designing a new and more democratic discipline system. The current system, which could lead to the loss of a license that costs many licensees hundreds of thousands to obtain, could simply be abandoned. One of the things that the task force could review is whether the State Bar Court judges should be under a completely separate and independent entity from the State Bar, so that there is an appearance that they are autonomous and can act in the best interests of the public and in the interests of justice. In the short term, the State Bar seal that is behind each bench in the courtrooms should be removed so that licensees do not have to feel that the prosecutor and the judge are both playing for the same team. The bar court judges should be in a position to serve as a check and balance on the overzealous prosecution of disciplinary actions. As it stands, it appears that the office of the Chief Trial Counsel is not overseen by or accountable to any person or entity. Second, if it is within the board's authority, it should direct the office of the Chief Trial Counsel to immediately impose a moratorium on the filing of any new disciplinary actions arising out of misdemeanor criminal convictions based on conduct that occurred more than 4 years ago and that did not involve moral turpitude.
Mr. Harrison, your time is almost up. If you could please conclude. Thank you.
My time is almost up. Okay. Well, Judge Harper Forte would like to share a recent issue that occurred to an African-American attorney who picked up 2 DUI cases in 2009 and 1 in 2011. He immediately went into treatment and got clean and sober and remained so until this day. However, due to the recent mandatory fingerprinting requirement, it was discovered that he had obtained the 2 DUIs. And even though they were not acts of moral turpitude and the Chief Trial Counsel readily agrees to that, he was brought in for discipline and charged, and he was forced to I'm kind of ad-libbing right now, but he was asked to either agree to discipline and obtain an admonishment that would have gone on his public record in order for the bar to not continue with prosecuting his license. Ultimately, the state bar decided not to prosecute him and to not make him agree to the admonishment. But this took a lot of internal work within the state bar, and it was, we believe, completely unfair to the licensee. This person should not have to endure that type of embarrassment for something that he was not legally required to do. And we would like, according to the written submission, for more information on the people and their demographics who are in the same position as this one individual licensee. Please, if you can, review the written submission so that you could see what COAF is requesting for the State Bar Board of Trustees today. Thank you.
Thank you, Mr. Harrison. Your written comments were shared with the Board of Trustees this morning. I do see the number of attendees who are seeking to make public comment is growing, and so that's going to limit the amount of time that we have for each individual comment. So I will, at this point, I see 15 people whose hands are up. I'm going to ask Mr. Aaron S. is the name that's shown, and you will have 2 minutes. I'm going to encourage everybody, please, not to repeat comments that have been made by other speakers when you give your comments. Aaron, you have 2 minutes. Thank you.
Hi, thank you so much. Do you have my voice?
Yes, we do.
Great, thank you. Thank you to the esteemed members of the board and the chair. So I attended California Bar Accredited Law School back in 2007. And shortly after my attendance, my brother was a bystander and he was shot in the stomach twice. Fortunately, he lived, but I had to deal through that. I'm sorry, I'm just out of breath. And so I graduated from law school, and then I got married, and I was diagnosed with a brain tumor, and I've been dealing with that ever since. And I've taken the bar multiple times. Unfortunately, I haven't been successful, and it's just been taking its toll on me and my family financially. I have a father that was bitten by the West Nile virus, and he's quadriplegic. He stays with us. I can't leave the house. There are times that I literally go sit in the car and I study for the bar in the car. I can't go to a library. I can't do anything. I would like to humbly request for the board, for the bar, for the Supreme Court to just allow people like me who have their own issues, and it's not just me, to be able to have the diploma privilege for all attendants that are applicable to take the bar. You know, I have attended a CPA college. I have passed the grades. I have paid my dues. I know the law. I have worked at law offices. I'll be more than happy to do anything that I can with attorneys supervising me.
Sir, if you could please conclude your comments. You have almost exceeded your time. Thank you.
Thank you. I appreciate it. And I just like to advocate for diploma privilege for all bar applicants. I appreciate your time. Thank you.
Thank you very much. We're going to move next to Ms. Savannah Wadsworth. Ms. Wadsworth, once you see a microphone icon, it's enabled and you will have 2 minutes.
Hi, can you hear me?
Yes, we can.
All right, so my comment was more on item 704. So I'm a bar applicant set to take the bar exam whenever it occurs. But I do understand that, you know, even if diploma privilege were to be granted to us this year, the future of the bar exam would still need to be discussed, which is the whole purpose of the Blue Ribbon Commission. One main point that I wanted to discuss was future accommodations. I mean, now that we know that online examination could be a possibility in the future if a pandemic were to happen again, I implore you all to look at the requirements for people that would have exam accommodations and not to single them out in forcing them to take the exam in person while everyone else is taking the exam online, because not only does it put their health at risk, considering they're mostly autoimmune, mostly people with autoimmune diseases and other issues, but also that the AI software picking up movements could single out people specifically because of their disabilities, which I think really does the bar exam a disjustice, and would force people to have to review all of the videos specifically of people that have accommodations rather than accounting for that possible problem. So that's actually the rest of my comment.
Thank you very much, Ms. Wadsworth.
Thank you.
The next person to speak will be Mr. Jake Pillard, or Pillard. I apologize for not being clear on the pronunciation there. Your microphone has been made available to you and you have 2 minutes. Thank you.
Good morning. Can you hear me?
Yes, we can.
Thank you. My name is Jake Pillard. I called during the last meeting, actually. I'm a recent graduate from University of Pacific McGeorge. There's 2 agenda items I would like to discuss. The ExamSoft contract approval that you have on your agenda, presumably for the online bar, and the potential postponement of the September bar. I want to stress that exam takers don't have access to the same kinds of testing environments. Some of us have families, small kids. People live in a variety of different places. Some people live closer to construction zones. Some people just don't have a quiet room, and others have roommates. Everyone has a different situation, and I really don't want this online bar to be about who has a suitable testing environment and who doesn't. And that's what I fear where we're kind of headed with this. So when you get to that agenda item, I hope you consider that and maybe just don't approve the ExamSoft contract for an online bar. And then on to, there's a potential postponement item on the agenda as well. We've already postponed the bar once. People quit their jobs to study for the bar. There's a variety of hardships here. I'm sure you're aware of them. Just quit moving the goalposts on people. We would all appreciate that. And I yield back the remainder of my time. Thank you very much for giving me a chance to give public comment.
Thank you very much, Mr. Pillard. The next person to speak will be Ms. Melinda Murray. Oh, excuse me. Depending upon who gets the microphone, it will be either Ms. Maya Blasberg, who is first on my list. And Ms. Blasberg, you have a microphone made available to you. You have 2 minutes. Thank you.
Hi, good morning. Good morning. Can you hear me?
Yes, we can. Thank you.
I don't believe I'll use the full 2 minutes. I just wanted to briefly pop in to seek some clarity. I am a recent graduate who is preparing to sit for the July/September/October exam. I know a lot of us have been waiting on an announcement about an official postponement to October. However, a lot of us saw this morning on our CalBar applicant portal that the date actually has already been changed to 10/5. So I just would like to kindly, respectfully seek some clarity as to whether there is going to officially be an online bar exam in October. I think we all just feel a little bit in the dark here because as of yesterday, it was still going to be September, and we were under the impression that we would get some clarity from the Supreme Court or from Cal Bar before any other kind of postponement was made. I echo all the previous comments that have been made about the inequities of a bar exam, and I still advocate diploma privilege for all. I just wanted to pop in and yeah, make you all aware that the date has been changed to 10/5 on our applicant portals. I yield the remainder of my time.
Thank you, Ms. Blatsberg. Mr. Steinbecker, I don't know if you want to address the fact that this will be talked about later, or who has the authority to make that decision, or if you'll wait until the item.
I'll discuss that in my chair's remarks, but very briefly, the Supreme Court will make the decision on whether there will be a bar exam and the date and any other issues regarding licensing for this year.
Thank you very much, Chair Steinbecker. The next person who we will be turning the microphone over to is Ms. Melinda Murray. Ms. Murray, once you have the microphone icon, please unmute it and you will have 2 minutes. Thank you.
Good morning. I'm speaking to agenda item 701. My name is Melinda Murray, and I am the president of the California Association of Black Lawyers and a deputy district attorney for the County of Los Angeles for over 30 years. California Association of Black Lawyers represents approximately 6,000 Black lawyers, judges, law professors, and law students. We have affiliate chapters in San Diego, Inland Empire, Orange County, Los Angeles, Santa Clara, and the Bay Area. I come to you today to urge your support of two of the reform measures before you with regards to the disproportionate enforcement actions against African American male attorneys. In potential reform item 1.1, the OCTC would specify a higher monetary threshold and one that allows a number of prior cases over a period of time before triggering investigation. This reform would greatly reduce the reportable action banks filing and actions where client trust accounts are overdrawn. Education about financial management is a more equitable solution. Also, we support potential reform item 3.1. The percentage of cases in which the respondent attorney is not represented by counsel was a statistically significant predictor of attorney discipline. We urge the state bar to track and report the proportion of discipline cases lacking representation as a key performance indicator. These reform measures will ensure the diversity of our fellow state bar members. Thank you for your consideration, and I will be on the call to listen to what comes next. Thank you so much for your time and patience.
Thank you for your comments, Ms. Murray. The next speaker is identified only as R, and you will get a microphone icon in a moment. As soon as you unmute that, you will have 2 minutes. Thank you.
Good morning. So there is an agenda item regarding the Council of Access and Fairness that is supposed to advance the state bar's diversity and inclusion goals. If you are looking to further your goals, then you can look no further than the meeting that you had with California bar applicants, which was recorded, by the way, where students of color and low-income students asked you to consider their hardships in taking a discriminatory, ableist, and racist exam. Students looked for you to show empathy and compassion, and we received none of it. Yesterday, as students with disabilities put themselves out there to ask questions about their accommodations, students were cut off and mostly given a cold shoulder as they asked for a fair and equitable playing field to take the exam. There is a major access to justice that is woven into the fabric of the legal profession, and it needs to be solved now. As of right now, your commitment to diversity and inclusion are empty promises that mean nothing to us unless you actually take meaningful action. If you're committed to diversity and inclusion, take a hard look at the trauma that you have inflicted on students of marginalized communities. I yield my time.
Thank you. The next person to speak is identified as concerned attorney. As soon as you have a microphone available to you, please unmute that microphone and you will have 2 minutes. I'm sorry, it looks like Ms. Escontrias, Pilar Escontrias has been given the microphone. We'll return to concerned attorney, or perhaps concerned attorney left the queue. But Pilar Escontrias, Ms. Escontrias, you have 2 minutes. Thank you.
Thank you. I'm Pilares Contreras. I'm here with United for Diploma Privilege. We're tired. If you can't hear it in my voice, this whole process has been exhausting. And I hope that Ms. Hershkovitz, you can hear, because this is really important. I saw you get up. I just want to make sure you're here. When we're here because we have to be. We have to unfortunately be present to articulate all of the reasons why we're disappointed with how this entity has handled itself in the past day alone. And I have a few questions, and I would respectfully like for them to be answered. The first relates to why the State Bar of California has updated its online portal to reflect an October bar exam. Chair Steinbrecher, you said the Supreme Court will make the final decision. We are well aware of this, but that doesn't answer our question as to why the State Bar, a separate entity from the Supreme Court, has changed the date. So my specific question is, why has the date been changed to October 2020 for the bar exam? Secondly, I respectfully request that this board identify how many individuals are present. You've either eliminated the function or you're not openly sharing that information. So we'd appreciate it if you would do so. And finally, on behalf of our coalition, I'd like to know what this board thinks about the behavior of the subcommittee on examinations yesterday. Yesterday, public comment was limited to 15 minutes. However, we were not given 15 minutes, and this was timed and it's recorded. We were limited to 8. 8 individuals spoke, despite numerous others being present who were there seeking accommodations. Whomever convened this meeting, I believe it was Paul Kramer, included the beginning portions of the roll call and all of that into our 15 minutes, which I don't believe is appropriate under the standards of this Board of Trustees and of this committee. Further, careless words were used, and it was frankly egregious that the committee did not seem to take into consideration that applicants with disabilities were present on that call.
Mrs. Contreras, you have almost exceeded your time.
Thank you. Even Alex Chan, who is a member of the California Bar Exam Working Group, this morning said on Twitter, quote, "I am disheartened by our CBE action. To all applicants with disabilities, I know nothing can comfort you regarding the bar exam. You deserve far greater and CBE's utmost respect. Know that I stand with you and will continue to advocate you for your best interests." So question number 1, why did the State Bar change the date? Question number 2, how many individuals are present? And question number 3, what is your response to yesterday's meeting? Thank you very much.
Thank you, Mrs. Contreras. And the next person to speak will be Mr. Tom Gordon. Mr. Tom Gordon, once you have a microphone, which I see now, you have 2 minutes. Thank you.
Thank you. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We are a national organization working to expand access for users of the legal system. We are very heartened by the bar's decision to look at the consumer interest and try to expand access to lawyers by establishing the Closing the Justice Gap Working Group, which is item 702 today. And we're particularly appreciative of the diversity of experiences and backgrounds that is being proposed for the working group. However, we do believe that there needs to be an expanded consumer presence on the group. Right now, there are 5 spots designated for lawyers, representatives of lawyer groups, and only one spot designated for a consumer. In addition, it's likely that several of the other positions, such as a trial judge and legal ethics expert, will also be lawyers. So while there are representatives of the CLA and the legal services community and defense counsel, we propose that there also be representatives of consumers, not just one consumer rep, but representatives of different socioeconomic backgrounds, representatives for seniors, for tenants, representatives for small business owners, for medium-sized business owners. These are all people that use the system regularly or should be able to use the system, and their perspective would be extremely valuable to reflect the diversity of views that they have and the diversity of their needs, rather than lumping them together as just one consumer. We'd also ask that, like the ATILS task force, that this task force also consist of a majority of non-lawyers. And
Mr. Gordon, you have 20
representation
seconds left. Thank you.
that greatly. I'd also like to add that in the interest of time, the Institute for the Advancement of the American Legal System, who had been hoping to comment, decided to just point out that they also are in agreement with the idea of expanded consumer and public representation on the working group. Thank you.
Thank you, Mr. Gordon. The next speaker will be Ms. Banashe Aklagi. Ms. Aklagi, once your microphone has been made available to you, if you will unmute it, you will have 2 minutes to give comment.
Good day. Am I being heard?
Yes, you are.
All right. Thank you very much. As announced, my name is Bana Shachlari, and I'm honored to address you as the current chair of the Legal Services Trust Fund Commission. I would like to thank Judge Brenda Harbin-Forte and the Council on Access and Fairness for inviting me to address this esteemed board. As you well know, COAF and the Commission are housed within the Integrated Office of Access and Inclusion. Under the leadership, vision, and foresight of Donna Hirschwitz, the office has been collaborating to better serve our work by having the policy side of our work inform our grant making and vice versa. Our diversity and inclusion work coming from the stewardship of COAF informs all of the work of the Office of Access and Inclusion. The Commission oversees IOLTA and other grants that fund about 100 nonprofit legal service organizations. This matter is of interest to us from our vantage point, and this matter I refer to is line item 701. We provide legal service grants to organizations who employ Black lawyers and lawyers of color who serve people of color. The Justice Gap study revealed that the legal aid community expressed the challenges that they face with their legal aid recruitment and retention. With the current findings of a disproportionate number of Black lawyers being disciplined or potentially disbarred, it begins to add to an already shrinking legal aid lawyer pool.
Ms. Akhlagi, you have 30 seconds left. Thank you.
Very good, thank you. Retaining legal aid lawyers of color is important to our work and important to the State Bar's efforts for greater access to and inclusion in the legal system by California's most vulnerable population. We support agenda number 401 for further study and fact-finding, please.
Thank you, Ms. Akhlagi. We're going to go what might appear to be out of order, but it's because the person identified as concerned attorney has returned to the queue. So we're going to move to concerned attorney. You should be given a microphone. I understand that might also involve a slightly different technical challenge that we're going to overcome in terms of giving you the microphone, and staff are working on that right now. And you've dropped off again. I'm not seeing you there. So unless you're somewhere where I cannot see, and staff will alert me to that, I think we're going to move then next to Ms. Alyssa Shire. Ms. Alyssa Shire, once your microphone has been presented to you, you should unmute it, and you will have 2 minutes. Thank you.
Yes, can you hear me now?
Yes, we can.
Thank you. So I'd like to reiterate that we would like the answers to 3 questions. I am also here with United for Diploma Privilege. 1, we would like to know how many people are on this public call. It's a matter of public record and we deserve to know that. 2, what is your response to yesterday's meeting regarding public accommodations? And 3, why has the State Bar updated the online portal to reflect an October bar exam? You have not answered any of these questions for us, nor have mentioned plans to do so, and we would like to understand why.
So Ms. Shire, my understanding is that public comment is for public comment, not for a conversation with the members of the board, although they will discuss those issues during when the agenda item appears. So I will take note of the questions that have been raised, and unless anyone on the board or Chair Steinbrecher would like to address that at this time, I think we'll move on to the next speaker.
Well, can I have the remainder of my time?
Yes, of course.
Thank you. I do appreciate you noting that. We just would really appreciate answers to these questions, as many of us have been staying up day and night trying to figure them out ourselves. I'd like to also urge the board to reconsider the contract with ExamSoft. This is a company that has grown exponentially within a period of 3 to 4 months, and they cannot deliver what they have promised to you. An online exam using ExamSoft would not just struggle to handle the capacity for California bar examiners. There are multiple states now that have decided to use ExamSoft software on October 5th through 6th. So we will have tens of thousands of students all trying to use the same limited software capacity at the same time. This is an unwise decision. We have technical experts that have testified on how this will be a catastrophic failure. I urge the board to reconsider the contract with ExamSoft, who has also not been transparent in terms of privacy issues or how they will provide a kind of how they will deal with the discriminatory effect of facial recognition software. Thank you. I yield my time.
Thank you very much. The next speaker that we have is Mr. James Aguirre. Mr. Aguirre, once you have a microphone icon, please activate it and you will have 2 minutes. Thank you.
Yes, good morning. And thank you for giving me the opportunity to speak. I hesitated to sign up to speak since I know there are so many applicants who need to have their voice heard, but I do think I have a unique perspective to add to the conversation, and especially for all of you who are members of the Board of Trustees. This is my 40th year of practice, and I am a former member of what was then the Board of Governors. I also served multiple terms in the Committee of Bar Examiners, and I graded the bar exam for 10 years through the 80s, and have been involved in the process for most of my long career. The administration of a bar exam in the best of circumstances is almost a miracle. And the admission process taken as a whole, including the grading process that leads to the results, have many, many, many moving parts. And I haven't heard a conversation about administering a complex exam, that being one with multiple components of different styles of testing, and grading it in the current climate presents its own challenges that make simplifying the exam itself, if one is to be administered, paramount. In other words, the process, for example, of calibrating and meeting to accomplish that purpose is complicated and requires many in-person interactions. And
Mr. Aguirre, you have 20 seconds. Thank you.
Okay. The critical piece here is that the only reasonable approach to take is to have diploma privilege under the current climate with a moving target where any administration of an actual exam is going to be beyond the capacity of the bar to carry out in the time frame that's allotted. But the other part of it is that the administration of an exam, if there is one, has to be open to all. And that means you can't discriminate between one class of applicants, the current class, versus anyone who qualifies under the law to sit for the California bar exam. And so I had that.
Thank you, Mr. Aguirre. The next speaker is Mr. Julian Sarkar. Mr. Sarkar, as soon as you have a microphone icon available to you, please unmute it and you will have 2 minutes. It looks like Mr. Sarkar has moved on. We have Haley Cohen. Ms. Haley Cohen, you have a microphone icon available to you. Please unmute it and you will have 2 minutes. Thank you.
Can you hear me?
Yes, I can.
Thank you. I'd like to speak on items number 704 and 705. First, I think it's unconscionable that during yesterday's subcommittee meeting to address testing accommodations, which usually include extended time, examinees were limited to only 1-minute comments. Additionally, an open public comment forum for only 8 minutes for the most vulnerable examinees is atrocious. I received testing accommodations which would require my exam to be administered and proctored in person. However, I have not received any information regarding how and when my accommodated exam would be administered since May 4th. And that communication was merely to inform me that my accommodations would carry over to a September exam. During coronavirus, I have had financial hardships and concerns, especially in Los Angeles, where I've lived my entire life and graduated from law school in May. I've been forced to move home with my parents, both of whom are high risk and work in high risk medical fields. As a first generation law student, law school was a risk I willingly undertook for myself. However, it is horrifying and inconceivable that I will now have to risk my life, my parents' lives, and the lives of their patients merely to sit for my accommodated in-person bar exam. In the best case scenario, I would be allowed to take the experimental online paperless and AI proctored exam at home. However, based on the rumors about what gets flagged as cheating during an AI proctored exam, the very basis and extent of my testing accommodations that my testing accommodations covered would get flagged as cheating almost as soon as I start the exam. It's unconscionable.
Excuse me, you have 30 seconds left.
A
Thank
bar
you.
exam in person, and with for those that have testing accommodations and inadequate at-home testing environments, and an online at-home bar exam is deeply inequitable. Administering a bar exam in the midst of an ongoing pandemic is grossly unconscionable, inequitable, and unduly burdensome. Granting diploma privilege is the only solution. Thank you. I yield the remainder of my time.
Thank you, Ms. Cohen. The next speaker is identified as Nicole B. Ms. B, you will be given a microphone icon. Once you see that, you can unmute it, and you will have 2 minutes. Thank you.
Hi, my name is Nicole, and I am also a current law school graduate, and recently have been thinking about the whole ExamSoft contracts that you have, and how I've actually used ExamSoft throughout my law school career, and how it's failed for many people at law school when they take exams and they are forced to have to use paper because it freezes on them, or something goes wrong, the number of questions that they have on there don't equate to the number of questions that they need to answer, for example. And I'm just thinking, how is ExamSoft and the State Bar going to ensure that these issues don't happen when thousands of people are going to be using it at the same time? If at the University of California, Irvine School of Law, only like 40 people were sitting in a class using ExamSoft for one test, and these issues came up where like the screen froze, or we lost our whole exam, or it wouldn't be submitted on time. How is the bar, the State Bar and ExamSoft going to make sure that students, like thousands of applicants who are taking the exam, are going to be able to adequately upload and take the whole exam the way in which they should be capable of taking it if they were to sit in person? I think this is a really big consideration. I know that when if you took the bar exam, you would have not personally wanted to take it online. Think about like having to move between screens for the performance tests. Think about having to look at a computer for hours and hours. Like I just spoke to a partner at the law firm that I'm hoping to work at, and he was saying that he barely knows how to type.
Your time is almost up.
I would consider these issues when you think about an online exam, and I would reconsider the contract you have with ExamSoft and advocate for diploma privilege. Thank you.
We're going to skip again to try to accommodate somebody who seems to be moving around on our screen, Mr. Julian Sarkar. Mr. Sarkar, we're looking to activate your microphone. And once I see you have a microphone available to you, you have 2 minutes. Thank you.
Good morning, Mr. Chair. Good morning, members of the board. My name is Julian Sarkar. I'm an attorney licensed to practice in California and New York. I've represented attorney applicants against the fraudulent business practices of the State Bar of California ever since the State Bar and its commercial business partner, the National Conference of Bar Examiners, bullied my friend to suicide in 2016. I want to address this, the State Bar's continued intention to carry out the California bar examination, continue to make tens of millions of dollars off of attorney applicants this year. The agenda item for the Blue Ribbon Committee says that the Blue Ribbon Committee intends to create a definition of an entry-level attorney either later this year or next year. This just further goes to show that there was never a factual basis, never any justification for the bar exam, just like in 2017. when the State Bar complained to our Supreme Court that it didn't have a clear definition of public protection, and therefore, which it did not expressly state, it would continue to require attorney applicants to continue retaking the exam, continue to give the State Bar tens of millions of dollars, and continue to claim without any factual basis that they did not meet the minimum competence required to become attorneys. Now, later today, this board intends to discuss a contract with one of its commercial business partners in carrying out the California Bar Examination, ExamSoft. I would ask that this board disclose all of its relationships with all of its commercial business partners in conducting the California Bar Examination. In 2017, the State Bar—
Mr. Sarkar, you have 15 seconds. Thank you.
Knowingly and intentionally misrepresented its relationship with Dr. Roger Bolus, the psychometrician it uses to conduct the California Bar Examination, stating that he had worked for the State Bar for 4 years. He's been working for you for 38 years. So I would ask that this board be honest in its execution and discussion of its contract with its commercial business partners, and refer to its own Office of Trial Counsel any intentional and knowing misrepresentations to the Supreme Court regarding its contracts. Thank you.
Thank you. I see now that we have not worked through the line at all because we keep getting new additions to the queue. I'm going to ask that people who request to make public comment limit their comments to a minute. I see also that concerned attorney, I see where you are, and we're going to seek to make your microphone active so that you can give your public comment, but I'm going to ask you to limit those comments to a minute. And can staff please activate the microphone of concerned attorney? Mr. Concerned attorney is listed now under panelists, which is where I now see that person. If we can't do that, we'll try to return to concerned attorney, and then see if we can work on the whatever we need to do to make that microphone available to concerned attorney. If we can then move to Ms. Miriam Sinobly. You have a microphone available to you. I'm going to ask that you limit your comments to a minute, please. Thank you.
Hi, my name is Miriam Sonboli. I'm a 2020 law school grad from NYU School of Law and a current bar applicant that would ask you all to not ratify the ExamSoft contract. I would ask you to consider the inequity that comes with conducting an online bar exam virtually, both for reasons that have been brought up already, such as wealth disparities that affect the availability of a quiet space and the racial inequities that come with allowing AI to be a part of the process that records and then flags potential instances of cheating to be reviewed, but also to highlight some of the other issues that ratifying the ExamSoft contract and permitting a virtual exam to go on could bring. For example, as we begin to enter California fire season, it's not uncommon for power companies to cut power with little to no notice. It's already been an issue for students studying for the bar exam online, and if an examinee taking the exam were to lose power, that would have a negative impact through no fault of their own. Further, one of the solutions suggested thus far has been a hotline via telephone to call into, but it doesn't address the reality that we likely wouldn't be permitted to have phones in the room when taking a virtual bar exam for fear of being accused of cheating. Please do not ratify the ExamSoft contract, which would permit the virtual bar exam to go forward. Diploma privileges for all is the only equitable solution. Thank you. I yield my time.
Thank you, Ms. Sonboli. We're now going to make an effort to get back to concerned attorney. I understand that concerned attorney has a microphone available to him or her. So concerned attorney, can you please give your comments? I am not hearing anything. Again, I think we're going to need to move on to somebody whose microphone we can activate. If staff would continue working on getting the microphone to concerned attorney, I think we'll need to move on to Brittany Leva. Ms. Leva, once a microphone is made available to you, you will have a minute to make a comment. Thank you. Ms. Leyva appears to have dropped off of the call. Jackie Nicole. Ms. Nicole, once the microphone is available to you, please unmute it, and you will have a minute to make your comments. Thank you.
Yes, hello, can you hear me?
Yes, we can.
Hi, thank you. While I support diploma privilege like my peers, I hope that if we are given a remote exam, I don't think there's been much talking about maybe leveling the playing field and erasing all of these security issues and scratch paper issues. Having to do a PT just seems impossible. I know that's already been covered, but I don't know why, and I hope it is considered maybe to have an open note exam to just level the playing field across the board and eliminate a lot of the security issues. I also wanted to briefly address the accommodations for disabilities that I didn't get to speak yesterday. I'm certain there's a wide range of medical issues that make people with disabilities more vulnerable to the complications of this novel virus. The disabilities I've applied for in the past and gotten approved of are not ones that would really be relevant necessarily because I haven't had to discuss autoimmune issues that I have, or a full thyroidectomy that I had to have for thyroid cancer and 3 years in remission. It would just make it really difficult for me to do an in-person exam if that is in fact what you're considering on basically discriminating against those with accommodations. It's very concerning to me.
Ms. Nicole, if you can please conclude your comments. Thank you.
Yep. Whatever format is ultimately decided upon, remote access for the exam should be allowed for all test takers, excluding the most vulnerable. For remotely taking the exam is discriminatory and denying us full accommodation without prior notice. Thank you for your time.
Thank you. The next person in the queue is identified as Esfe. I would like to turn the microphone over to Mr. or Ms. Esfe. Once your microphone's available, if you will unmute it, you have a minute, please. Thank you.
Yes, thank you so much again for your time. I know you all have very tough decisions to make, and I definitely don't want to be in your shoes. But in terms of testing with accommodations, I was hoping to be able to take the test remote, or at least have the option to take the test remotely, just like everyone else. I don't know if the technology is the barrier or what the issue is. If it's a technology issue and it's not possible at all, then someone like me, I live with my 2 toddlers. I live with my with their elderly grandparents. I myself have asthma. So if it is possible to have a private room or something that really reduces the risks, I honestly cannot afford to get sick. And I know a lot of people are on the same boat.
Thank you. If you can conclude your comments, please. Thank you.
Yes. So that is my request, either being given the option to take the test remotely as with accommodations, or having a private room to have all people with accommodations have that option, if that's possible at all. Thank you so much again for your time.
Thank you very much. I'm going to jump the line to go back to Ms. Brittany Leyva, who had been called on earlier and then had moved through the line. So we're going to seek to go next with Ms. Brittany Leyva. And following that, I see concerned attorney again in the queue, and we'll try to go with concerned attorney after Ms. Brittany Leyva. Ms. Leyva, you have a minute. Thank you.
Hi, can you hear me?
Yes, we can.
Hi, I wanted to highlight the previous comments with respect to diploma privilege, and I also wanted to address the exam's utilization of artificial intelligence and how there have been multiple reports written about the discriminatory nature of artificial intelligence, especially with respect to its programs and algorithms. And I urge you all to read the ACLU's report on the uses of artificial intelligence and a study conducted by MIT. Next, I do have some questions about the CCPA and privacy concerns, and how the contract to be discussed later on today it includes licensing examinees' images and storing examinee biometric information. And I wanted to ask or to have some light shed on how our biometric information, because it does fall within the definition of biometric information within the CCPA, how that's going to be used after, should an exam happen after the exam is done in October. And thank you, I yield my time.
Thank you very much. The next person we'd like to put into the queue to speak would be a concerned attorney. A microphone should be made available to you. Once you see that microphone icon, if you can unmute that, you will have a minute to give your comments. Staff are working to activate your microphone, concerned attorney. And we appear to have lost you again. Okay, the next person in the queue would be Mr. Jake O'Neill. Mr. O'Neill, you will have a minute to give comment, and your microphone is available to you.
Hello.
Yes.
My name is Jake O'Neill. First, please stop calling on concerned attorney. You've now called on him 5 times. He spent more time failing to speak than you're giving other people the time to speak. Second, since the board has decided it's not going to respond to the questions until later, I'm going to point out the obvious. The exam date's been changed to October 5th, and the board is about to ratify a $3 million contract with ExamSoft. In other words, congratulations to the bar. You have succeeded in your advocacy for forcing us to take an online bar exam in October. You definitely had an uphill battle with the facts against you in all common sense, but you seem to have prevailed, so congratulations there. Finally, I just have one question for the board. I'm curious if the board has any plans for the defense and lawsuits it's likely to face. I'm sure that you're all aware of the elements of intentional infliction of emotional distress and negligent infliction of emotional distress. I imagine there's going to be lots of lawsuits. I'm not sure how many applicants there are for the California bar, but it seems any of them would have a great case against you. So my question is how the bar plans to defend against those lawsuits. With that, I yield my time. Thank you.
Thank you, Mr. O'Neill. The next person in the queue is identified as Octavia. Octavia, once your microphone has been made available to you, if you would please unmute it, you'll have a minute to give comments. Thank you.
Hi, I just have a quick statement that I want to make. I am very uncomfortable with the idea of AI technology being used on me, especially since it will indeed violate my privacy rights. Having a robot looking into my apartment and using that data for whatever reason is definitely creating a bit of anxiety, more than even the bar exam would. Also, I'm a Black applicant, and I have a hard time understanding why you all would choose to use technology that will present complications for Black applicants and further discriminate against us. If you can take some time to explain how that will be mitigated, that would probably make us feel a little bit better, but I still don't really buy it. Thank you.
Thank you very much. The next speaker is Juan Manuel Suero. Mr. Suero, once your microphone's available, you will have 1 minute to give comments. Thank you.
Good morning to the board. Can you listen to me?
Yes.
Thank you. It's an honor to speak with you. First of all, I'm an attorney. I have been a practicing attorney for 27 years, and I am living in California because of family circumstances, health, to be more specific. My words are not to discourage. Au contraire, it's to encourage this board to use logic. We all have one thing in common, too. First of all, we all drink water. And second of all, we all use the bar exam to determine the competence of lawyers. At this moment, according to the statements that I have been reading and research and all this stuff, it seems like the bar exam is not able or is not the perfect way to determine the competence of a lawyer. same like water. If we make a comparison, it's like we have to drink the bar applicants unfiltered water. We can have other methods to determine the competence of lawyers.
Mr. Suero, if you can please conclude your comments, thank you.
Yes, I encourage this board to seek other options, logical options to protect the consumers. Thank you.
Thank you, Mr. Suero. The next person in the queue is listed as diploma privilege. Once your microphone's available, you will have a minute to give comments. Thank you. That person has now dropped off. Oh, nope, they're back. Your microphone is now available to you. The person identified as diploma privilege. If you could please unmute that, you'll have 1 minute. The microphone icon there and has dropped off again. Okay, let's move on to Hani Havas. Mr. and Ms. Havas, once your microphone is available, you'll have a minute to give comment. Thank you.
Thank you. Can you hear me?
Yes.
Yes. I just wanted to put emphasis on the fact that if there are technical errors during the bar exam, I'm looking at it from the point of view as, okay, let's just say we're going to be taking it. If there are technical errors, we were told that there'd be a phone line and we can call in. And my understanding is that we aren't allowed to have phones while taking the exam in the exam room. My other concern, which has been echoed by my colleagues, is that, you know, what if the phone lines are overloaded with thousands of calls at the same time? I think that's something very important to resolve and to look into. And then lastly, I've put in more than 300 hours of bar study time. I'm not one of the people that is looking for diploma privilege just to get, you know, my license. I'm willing to go one way or the other. I don't care. But when it comes to actually studying for the examination, I would ask with respect to your negotiations with ExamSoft, if there is going to be a test, that we are given the opportunity to utilize ExamSoft to practice the way that we're going to be tested. This means taking the test, the MPT, MBEs.
Thank you, Mr. Habas.
Thank you.
The next person in the queue is Basilio Mendez. Basilio Mendez, once your microphone is available, you'll have a minute to give comments. There you go, Mr. Mendez.
Yes, I'm one of the lucky ones. My offer of post-bar employment was rescinded, but I know where my next meal is coming from. I know that my rent will be paid, that I will have stable internet access if this year's exam is administered online. And even with my post-bar offer being rescinded, I'm able to afford a bar prep course because my partner is still employed. My partner is still employed because he is a nurse at St. Francis Hospital in San Francisco. And for those of you who may not know, by Mayor Breed's order, St. Francis houses the COVID critical care unit in San Francisco. Just the other day, Mayor Breed delayed for the second time the next phase of opening San Francisco because the numbers are not getting better. I worry every day if my partner has been exposed. I worry every day if he will come home. I can't even begin to imagine what my partner and his colleagues are called to do every day. And still, this man comes home and comforts me because he knows how much stress I am under. He comes home and comforts me after a day of being on the front lines of California's first wave of COVID, while I've been sitting at home doing practice questions. Please read the report offered to you. Please take the advice offered to you by the deans of our law schools. Please consider diploma privilege with guardrails if you must, as the only humane option for the applicants. Also, many of my friends were not privileged enough to be born in this country as I was, and are facing deportation if they need to wait to find employment for another 6 months because of this delayed exam and getting results of whether they will be barred attorneys. Please take into consideration students.
Thank you, Mr. Mendez.
And those of us who were accepted into LLM programs.
The next person in our queue is Dominic Nicolosi. Mr. Nicolosi, your microphone is available to you. If you unmute it, you will have a minute to give comments. Thank you. Mr. Nicolosi, your microphone icon indicates that it's still muted. Mr. Nicolosi, if you could unmute your microphone, you'll have a minute. There we go. We should be able to hear you now. Mr. Nicolosi? Mr. Nicolosi, we're not hearing you. Mr. Nicolosi, I believe we're going to need to move on. If we don't hear anything, I'm going to ask to move on to Ms. Whitney Williams. Ms. Williams, you have a microphone icon. Once you unmute that, you'll have a minute to give comment. Ms. Williams? I heard you for a moment there, and now your microphone, there we go. Can you speak, sir, Ms. Williams? Ms. Williams? Ms. Williams, your microphone's available to you. Okay, let's move to Mr. Victor Lopez. Mr. Lopez, you have a microphone icon available to you now.
Yes, sorry, can you hear me?
Yes, we can. Thank you. You have a minute.
I just want to share my story. I'm a single father. So I have legal and physical custody, 100% legal and physical custody of my 2 kids. Working from home, one of them was homeschooled starting in March. We got notice that the schools are not opening back up. So as a recent graduate, it's just extremely, extremely hard to even just focus on studying. Again, I'm not one to shy away from hard work. It took me 6 years to graduate, and I know what hard work looks like. But I just want to share my story. That's it. I yield my time.
Thank you, Mr. Lopez. The next person in our queue is Ms. Whitney Thompson. Ms. Thompson, you'll have a minute. Before you begin your comments, though, let me just note that it is 10:52. The board has been hearing public comments for about 50 minutes now. We're going to seek to end the comments at an hour roughly of public comments, so at about 11 o'clock. So that means that if everyone limits their comments to about a minute, we'll make it about as far as Ms. Betsy Crowder. So for those of you who can see who's in the queue there, I just wanted to note that we're going to need to return to the business of the Board of Trustees following public comment. Ms. Thompson, you have the floor.
Hi, can you hear me?
Yes, we can.
Hi, thank you for giving me the opportunity to speak. I, of course, advocate for diploma privilege for reasons that my fellow applicants have stated, but in the event that we are not granted diploma privilege and have to take a remote exam, I also think we should consider an open note or open book exam. I think we can all agree that the actual practice as a lawyer is open book, and it will alleviate security concerns and concerns about being discriminated against or flagged by the AI software for cheating. Also, as a student with testing accommodations, I am hoping that I am not forced to risk my life to take the test in person while everyone else is allowed a remote test. So please keep that into consideration, everyone's health. Thank you. I yield my time.
Thank you, Ms. Thompson. The next person in the queue is Beth Patel. Ms. Patel, your microphone is available to you. There you go, and you have a minute. Thank you.
Hi, thank you for taking public comment today. I am here also speaking up for diploma privilege on behalf of thousands of bar applicants that have addressed this body before and have addressed other bodies like this one before, asking for the same thing. We have yet to hear any response to the thousands of people that have been calling in and asking for exactly this. I wonder if there has been or is or ever will be any evidence that the bar exam actually is a measure of competence. I believe no competent attorney would ever rely on what they've memorized for the bar exam in order to represent a client. Furthermore, the entire point of standardized tests, which we know have disparate impact on people of color and especially Black applicants, are supposed to be standard for that very reason is that they are standardized tests and they should be even across the board. An at-home test is absolutely not going to be standardized, and there is literally no way that the bar examiners or the California Supreme Court can ensure that it will be standard. Furthermore,
Ms. Patel, I'm going to ask you to conclude. Thank you.
I implore the State Bar of California to advocate for diploma privilege. Right now, we need creative solutions to their impending economic crisis.
The next person up is Mr. Matt Chipman. Mr. Chipman, your microphone's available to you. If you will unmute it, you have a minute to give comments. Thank you.
Hello, can you hear me?
Yes, I can.
So I've been on the call since earlier this morning, and I've so far counted 5 people who have not been able to talk because of connection issues or being able to unmute. That is Ms. Levy, concerned attorney, diploma privilege, Mr. Nicolosi, and Ms. Williams. If they were taking a bar, that would be 5 people who possibly would have failed because of their internet connection and not because of what they know. Please do not ratify the contract with ExamSoft. Please consider diploma privilege with guardrails and supervised practice. I yield the rest of my time.
Thank you, Mr. Chipman. The next person in the queue is Betsy Croder. Ms. Betsy Croder, once your microphone's available, you'll have a minute to give comment.
Hi, can you hear me?
Yes, I can. Thank you.
Thank you. My name is Betsy Crowder. I also advocate for diploma privilege. However, in the event that there is going to be a bar exam, I'd like to mention a couple things. A remote exam, as my fellow applicants have stated, is extremely discriminatory. However, I'm not sure that the State Bar Committee has thought through all of the reasons why. For example, requiring test takers to do a PT without scratch paper or do wills and property essay problems or property MBE questions, which is 25 questions out of during a normal bar exam without scratch paper, is impossible. Secondly, some applicants will have access to computers that work like tablets where they can underline and highlight things on a PT or an essay, whereas other applicants will not. This will give them a big advantage over other applicants that do not have these kinds of computers or be able to buy one in order to take this exam. It may also look like these test takers are cheating.
Ms. Crowder, if you could please conclude. Thank you.
Thank you.
Thank you very much. We're going to conclude the public comment session now. We have a number of people waiting in the queue. However, it's been almost an hour and the line the number of people in the line continues to grow. So I'm going to turn it over to Chair Steinbrecher. Return the gavel.
Thank you very much, Mr. McLeod, and thank you for running the public comment as efficiently as you did. The next item on the board's agenda is number 10, minutes. The open session minutes from the May 14, 2020 meeting. I will dispense with the reading of the minutes. Unless there are any changes or suggestions or questions, I will deem the minutes approved. Are there any such comments, questions, or suggestions?
Chair, this is the secretary. We will need to take a roll call vote because this is a teleconference.
Oh, that's true. Yep. Okay. Please. Thank you.
Broughton. Actually, is there a motion? Is there a second?
So moved.
Jose.
This is Debbie. So moved.
I'll second it, Jose.
Ms. Manning moved and Mr. Cisneros seconded. Please call.
Broughton.
Yes.
Chen. Yes. Cisneros.
Aye.
Dela Cruz. Dellen.
Yes.
Duran.
Aye.
Iglesias.
Yes.
LeBron.
Yes.
Manning.
Yes.
Bertula.
Yes.
Selig.
Yes.
Stallings.
Yes.
The minutes are adopted.
Thank you. The next item on the agenda is 30, the chair's report. Several topics to share with the board and those of you who are listening. Regarding the California bar examination this year, the staff and board has been working hard since April, pursuant to the Supreme Court's direction, to explore the feasibility of delivering the California bar exam remotely this year. We've been in frequent communication with the court on our progress, and we've kept the court apprised of our efforts. We believe the court will be making its decision regarding this year's bar examination soon. I do want to recognize and congratulate the bar staff, both Donna Herchkowitz, our interim executive director, and Amy Nunez, our director of admissions, and the entire administration staff for all the hard work that they have expended in bringing us where we have come in a very short period of time and under a great deal of stress. As to a couple of the questions that were raised during the public comments, I'm not going to try to respond to them all or in detail, but I will say just a couple of things. Number one, the ExamSoft contract that is on the consent agenda today is not a contract for the online version of this bar exam. It's the standard contract for the software for anyone who takes the in-person exam on their laptop. It covers the California bar exams through February 2025 and the first year law students exam through 2024. Second, we have always accommodated certainly people with special accommodation needs, and we've heard your concerns, and we will look into expanding that as best as we can. The artificial intelligence just flags the videos for layers of human review. It's not to be an intrusive invasion of your privacy. So next, I want to talk to, well, I'd like to extend my thanks again to the entire State Bar staff for being so adaptable in making the working remotely, a program that we've been under since March, the great success that it's been. Your productivity has remained very high. We've had great cooperation among the entire staff, and it reflects your dedication to achieving the bar's mission of public protection and access and inclusion and diversity. And I want to thank you for all of those efforts. Third, the executive director search is nearing conclusion. The board will interview the finalists tomorrow. To the board members, I realized late last night that a calendar schedule had not gone out, although there had been some discussion about using tomorrow for these interviews. Not everyone had gotten that message. So please, the board will meet tomorrow beginning at 10 o'clock to interview the finalists. The search for the chief trial counsel is underway and progress is being made. The fee bill, the last time we met, the fee bill had cleared the Assembly Judiciary Committee. Since then, it has cleared the Appropriations Committee of the Assembly and the entire Assembly from the floor, both by consent. So I want to thank very much everyone who has put their efforts into the fee bill creation and discussion with the legislature. We will be meeting next week with the members of the Senate Judiciary Committee, and so our fee bill is moving to conclusion. Finally, I want to thank the board. This has been a very unusual year for everyone, including the Board of Trustees. It's required a tremendous amount of effort on the members of the board to put in time and effort beyond that which is just normally required of a board member. People have stepped up to head special committees, working groups, and have taken a lot of time to help negotiate the very difficult environment that we have been in. So I want to thank each member of the board very much. And that concludes my chair's remarks. So next on the agenda is, I believe, the executive director's remarks.
Sorry about that, I was muted. Thank you. For me, the process of determining what to include in my written executive director's report to the board, as well as in my oral comments, involves a fair amount of reflection. Reflection on what happened, what has happened at the bar and in the world since the last board meeting, what's happening at this board meeting, and the direction that I think the board should be looking toward for the future. And so in that context, I think the most important thing for that we can be talking about is racial disparity, striving for equity, and the critical importance of inclusion and diversity efforts. The State Bar has been critically self-examining our work and our systems. Item 701 on our agenda today takes us right into the middle of that discussion. The State Bar's analysis of disparity in the discipline system found that African-American male attorneys receive considerably higher numbers of complaints than their white counterparts. They have a higher number of investigations conducted against them and are disproportionately unrepresented by counsel in our discipline system. The fact that disproportionate discipline against African-American male attorneys can be explained statistically by these factors does not change the fact that these attorneys are more likely to receive serious discipline from the State Bar. The State Bar has an obligation to ensure a discipline system that is free of bias and discrimination, and I hope we will listen carefully to Professor Robertson when he speaks to us this morning and take some bold action and stem that tide. But that is far from all we are doing on these important topics, and it's certainly not all that we should be doing. Tomorrow, the State Bar will be releasing its first annual report card on diversity in the legal profession. This report brings into stark reality that despite the fact that the proportion of attorneys who are women and people of color has grown over the past 30 years, California's attorney population remains far from reflective of the state's diversity. The State Bar must push forward without delay on the important concrete objectives we've established to help the profession move toward greater diversity and inclusion. The report card provides a tool for accountability for ourselves and also a stimulus for others to take action. The report card the issuance of the report card will be followed by a series of sector-specific diversity summits, starting with the private sector, to see how we can move the needle on inclusion and diversity in the ranks of the private sector, in leadership positions for attorneys of color and for women, and career satisfaction for both as well. And we need to examine, as we've heard today, we need to examine the front end of the profession as well. At the last board meeting, you approved establishing a joint Supreme Court State Bar Blue Ribbon Commission on the future of the bar exam. And today you're being asked to approve the charter and the categories for membership on that commission. That commission will have a tremendous responsibility, not just to think about the topics to be included in the exam, the format of the exam, and the cut score. I hesitate because I said just doing those things. That seems fairly substantial, but it must also think about the historic differences in passing rates between white and non-white applicants. The commission must dig deeper than the analysis we've already performed, looking at the differential performance of each question, but ask itself if the system somehow creates inequity and racial disparity, and more importantly, figure out how to change that. So we have a big day ahead of us, and so I don't want to take up much more of your time. However, as they say in Robert's Rules, I do want to take a point of personal privilege. I've had the opportunity to talk with most of the board members about this, but unfortunately not all of you. Assuming that all goes well with the executive director finalist interviews tomorrow that Ellen mentioned, this will be my last executive director report to the board. For a variety of personal and professional reasons, I have opted not to apply for the executive director position myself. I wanted to take the opportunity to thank the board for putting its faith in me over these past 6 months to run and help shape this organization, at least for this limited period of time. And I wanted to thank the board for the tremendous amount of work that I have asked of each of you and that you have given me over the past 6 months. It seems like the number of obligations on trustees has grown as the size of the board has shrunk. We have asked some of you to participate on the executive director search committee, the Chief Trial Counsel Search Committee, an informal working group on the bar exam, to chair the paraprofessional working group, to serve as informal advisors on our attorney supervision redesign project, to meet with applicants for the bar exam and deans at our law schools. And those are just the first few things that I pulled off the top of my head. Further, to ensure that these board meetings in the times of this pandemic run smoothly, we've split the board meetings and committee meetings over several days, asking for more and more of your time. I speak with several of you almost daily, it seems. When I assumed the executive director role, the interim executive director role in mid-January, I don't think any of us could have predicted what the following 6 months would look like. I set goals for my interim period, which were made almost immediately irrelevant, or at least considerably less important by the changing times. Simply stated, we threw away the planning documents and played it largely by ear. I'm proud of the job I've done, and I hope that you and the staff here at the State Bar feel the same way. I hope you feel that I've given you as much as you've given me during this period. And with that, I conclude my remarks and will let you move on to your busy agenda.
Thank you very much. All right, the next item on the agenda is the consent agenda. Does anyone want to pull any items off of the agenda?
Yes, I need to pull out 50-8.
50-8. Okay.
Mr. Chair, Brandon Stallings, if I could have 50-2, 54-111, and then 54-117. Pulled off, please.
Okay. Anything else? All right. As to the remaining items, we can deem those approved upon a motion for all of them. That is all items on the consent agenda except 50-2, 50-8, 54-111, and 54-117. Chair will entertain a motion to that.
So moved.
Jose, I'll move.
Oh, I'm sorry. Brandon Stallings moves, and second by
Jose Cisneros.
Jose Cisneros. Is there any comment or? All right, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Bertula,
Yes.
Selig,
Yes.
Stallings.
Yes.
All right. Item 50-2. Who, I think, Ms. Hershkowitz, I think this would be your
Yes. So this item identifies 3 contracts that were entered into in the period between board meetings that normally would have been brought to the board's attention. The contract with ExamSoft Worldwide, as the chair mentioned in his remarks, this contract does not relate to the a delivery of an online exam. It relates to the laptop licenses and extends for a multi-year period. This is the same contract we would enter into. We have entered into in the past to allow applicants to be using a laptop on site at our testing at our test sites. This is not related to the administration of the current exam, whether that be online, remote, in person, or anything. The next contract on this list is with Polyrific. As part of its approval on the budget earlier this year, the board approved $1.7 million for expenditures for our Odyssey case management system, for our discipline system. Part of this contract with Polyrific is to implement those pieces of the Odyssey case management system, which were outlined in that budget item, that we would be contracting out for with an entity other than Tyler Technologies. And the final item on this list was a contract for a desktop or a laptop refresh. Also, this was approved by the board in the budget when we just approved that earlier this year. Additionally, this was part of the funding that was approved as part of the license fee increase by the legislature and the governor, that there would be funding for desktop refresh. In light of the coronavirus and the fact that so many of our staff are working from home, we switched our direction, and instead of determining who would get desktops and who would get laptops, this contract would have everybody be getting a laptop, as most of the individuals are working from home. Happy to answer any questions.
Are there any questions for Ms. Hershkowitz? Are there any other questions, comments, or questions or comments on this consent item 50-2? Hearing none, I will entertain a motion to approve 50-2. So part
Sonia second.
moved by Ruben Duran,
Sonia Dellen seconds.
seconded by Sonia Dellen. Please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Pertula,
Yes.
Selig,
Yes.
Stallings.
I have recused myself from any issues relating to the administration of the bar exam, and in the abundance of caution, and am abstaining from this particular vote.
The motion carries.
Thank you. Before we go on to the next item on the consent agenda, I just want to give the board an idea of my schedule for the morning. I want to complete the items on the consent agenda and then take a brief break, come back of about 5 minutes or so, come back and then go until 12:40, at which time we'll take our lunch break. All right, 50-8, and I'm sorry I don't know who asked to have this pulled.
Me.
Oh,
Nay.
LeBran? Yeah, do you have any questions, or should we, do you want an explanation from Ms. Hershkowitz? Oh.
Sorry. So 50-8, sorry, I wasn't prepared for these. 50-8 asks for the giving the authority to the chair of the paraprofessional working group to appoint some additional members. And we have 2 vacancies on the working group, which have as yet to be filled and could benefit from additional participation and additional diversity of members. And so while we put out a solicitation for those members, in order to get them on board as quickly as possible while the paraprofessional working group is doing its business, we don't want to hold that up, and we want to get these folks started. We were hoping to be able to solicit those names and have the chair, Chris Iglesias, appoint those members without returning to the board.
Are there any questions for Ms. Hershkowitz?
I would move the item.
Moved by Mr. Stallings.
Duran, I'll second.
Seconded by Mr. Duran. Any further comments or questions? Please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes, and thank you.
Trustee LeBron's recusal is noted. Manning,
Yes.
Pertula,
Yes.
Selig,
Yes.
Stallings.
Yes.
The motion carries.
Thank you. Item 54-111, pulled by Mr. Stallings. Is that because you're exercising your recusal?
Yes.
Any other questions or comments that you have? It's just
no.
Okay. Does anybody have any questions or comments on 54-111? All right. Is that the same for 54-117, a straight recusal?
Yes, Mr. Chair, it is.
Okay. Does anybody have any questions or comments on 54-117? If hearing none, the chair will accept a motion to pass both 54-111 and 54-117.
So moved.
Moved by Ms. Manning, seconded by Mr. Broughton. Please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dellin,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Bertula,
Yes.
Selig.
Yes.
Trustee Stallings' recusal is noted for both items 54-111 and 54-117. Both motions carry.
Thank you. All right, it's 11:21. Let's take a break until 11:30, come back and be in session until 12:40, at which time we'll take our lunch break. Thank you.
I don't believe that's necessary, Chair.
All right, very good. Are we recording again?
Yes, we are, Mr. Chair.
Thank you. All right, welcome back. Continuation of the Board of Trustees meeting. We are now on agenda item number 100, reports of board committees. I'll report for the board executive committee, which met this morning. Before this meeting, we had a number of agenda items to approve, which we did. Most of them were 54-111 through 119, which are appointments to various boards and so forth. However, there was one topic, one agenda item that the entire board needs to approve, and that's an approval of an addition to legislative priorities. The brief summary is that this would add one addition to our 2020 legislative priorities. It's to support a bill, SB 1447, that's been introduced by Senator Stephen Bradford. And what this would do is restore a provision of the Business and Professions Code, section 6106.3, concerning or restoring the cause for discipline against an attorney who violates a civil code section, actually 2944.7, which requires certain disclosures and conduct in connection with advising people about mortgages and mortgage advice in general. This is a provision that was originally in 6106.3, but inadvertently that came under a sunset provision. So it has now been sunsetted out. And this legislative priority would be in support of Senator Bradford's bill, Senate Bill 1447, to restore that previous provision. This being a report from a board committee, I, as the presenter, am presumed to be the mover of the recommended action. There's no second required, so we have a motion on the floor. Is there any discussion or questions? All right, then we'll assume that we have the motion teed up, and Ms. Cohen, will you call the roll, please?
Would you like me to project the resolution?
You know, you should, please.
There you go.
Thank you. Give everyone just a second or two to look at it. All right. Hearing no questions or comments, Ms. Cohen, will you please call the roll?
Broughton,
Yes.
Chen, Cisneros,
Aye.
Dela Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Bertula,
Yes.
Saleg,
Yes.
Stallings.
Yes.
Motion carries.
Thank you. The next item is 120, Regulation and Discipline Committee Report. Mr. Stallings. Unmute. Unmute, Brandon. There you go.
All right. All right. Thank you, Mr. Chair. The staffers of RAD, Vice Chair Ruben Duran, and myself have been hard at work in preparation for the July RAD meeting, which was conducted on Monday of this week. On that date, we also had a joint meeting of RAD and the Executive Committee to discuss the evaluation of the Chief Trial Counsel. I would like to thank all of the staff and board members who participated in this important work. The Chief Trial Counsel Search Committee met. It's composed of 3 trustees, Sean Saleg, Chris Iglesias, and myself. We had a meeting with the Hawkins Group where we had a productive discussion about this important search. The attorney supervision review continues to move forward. That relates to the probation system and revamping it to include more evidence-based practices and the exploration of potential diversion programs. At the bench bar committee meeting, RAD chair and vice chair have been hard at work with the input of State Bar Council, or State Bar Court rather, Defense Bar, OCTC, and OGC in discussing the rules that this board just approved to be put out for public comment. I would like to thank members of the State Bar Court and Defense Bar in the tremendous amount of work and collaboration that has taken place over the past several months, and to Steve Moad, Melanie Lawrence, Andrew Tuft, and the staff at OCTC and OGC for your hard work in those areas. In response to the FARCUS report and findings, I asked for a subcommittee to be formed at the bench bar committee level for further collaboration and information sharing with State Bar Court, OCTC, and Defense Bar. On June 16th, we had the pleasure of having Professor Robertson address the subcommittee. And as we will see later in the agenda, several of the items that Professor Robertson is proposing for immediate action require some buy-in from both the Defense Bar, OCTC, and State Bar Court. I'm pleased that this group of individuals has taken this issue on and is willing to continue to collaborate. I was also pleased to learn that OCTC has been reaching out to pro per litigants at an early stage to request mitigating evidence so cases can be fully evaluated and litigated. The Defense Bar has been very receptive about the pro bono panel and continued to discuss logistics on how best to implement this. State Bar Court personnel has discussed the logistics of posting more informational items for pro per litigants to use as self-help aids, further aiding in self-represented respondents' desire to represent themselves in a fully informed manner. Later in the agenda, you'll see our very own Randy DeFentorum's presentation on the status of an important work that started in January of 2018. This project studied the use of self-diagnostic tools to expose gaps in the knowledge of lawyers and highlight areas where misconduct could occur. And this diagnostic tool would be available for all lawyers and is especially designed to assist sole practitioners and owners of small firms. This diagnostic tool touches on elements of Professor Robertson's recommendations, and I'm proud of the continued work of this board to protect the public by studying and implementing ways to prevent future harm through proactive measures and equip lawyers with training so that they may avoid common mistakes. The last thing I'd report is that Chair Steinbrecher has also tasked me with an initiative involving civility in the practice of law, and I look forward to bringing more information on this to the board in the near future. So thank you, Mr. Chair.
Thank you, Mr. Stallings. Finance, Ms. LeBron, do you have anything to report?
Yes. Hang on, let me just pull up my notes. Sorry.
Chair, this is the secretary. I'm sorry to interrupt. Is there a vote needed on 124? consideration of attorney self-assessment models.
Well, I believe there is. Thank you.
So, Mr. Chair, because this is Brandon Stalling, so just because this is coming out of RAD, I think it just requires a second and then a vote.
It requires no second, actually, or a motion. It just requires a vote.
Can I ask a question about this?
Sure, please.
So I probably should have asked this during RAD yesterday, but the only question I had about this item was, it was just slightly unclear to me what we're approving, in the sense that the fiscal impact is not described and it's sort of to be determined. So once we have a more final proposal for implementation and the cost estimates and so on, I assume it's going to come back for approval or not?
Is Randy on the line?
This is Randy Diefentorm, Office of Professional Competence, and Sean is precisely correct. What we wanted to do is identify the model, which is the specific task described in the strategic plan goal 2 subpart E. And the model could have been something very low tech like a workbook, or it could be a online interactive system, much like our e-learning initiatives. And so what staff has recommended is that we do something that is more robust than online interactive program, and that we will need to engage a vendor to identify the potential costs, and that we would be coming back with a specific proposal for an actual implementation plan. But we needed to know the parameters of exactly what we were doing, whether it would be online, whether it would be gathering data, as opposed to just, again, putting a PDF online for folks to download. So we're very grateful that RAD has agreed with the idea that we should go for a robust program similar to the Colorado program, which was presented to the board at the 2018 strategic plan. And that is what this resolution contemplates, that the staff will actually create an implementation plan that accounts for these aspects of a model for self-assessment.
Okay, great. Thanks, Randy. Thanks for your work on this.
Sure.
Any other questions? Okay, a motion on the floor and deemed seconded. If there are no other comments, Ms. Cohn, please call the roll.
Broughton?
I'm not on RAD. Am I supposed to be voting on this as on the board?
Yes.
Okay, yes.
Jen? Yes. Cisneros?
Aye.
Dela Cruz? Dellen?
Yes.
Duran?
Yes.
Iglesias?
Yes.
LeBron?
Yes.
Manning?
Yes.
Pertula?
Yes.
Selig?
Yes.
Stallings?
Yes.
Motion carries.
Thank you. And now Finance Committee, Ms. LeBron.
Sure. So, so we met on July 6th. We had a consent item, which was the adjustment of fees and penalties that we do regularly. We also had an update on the real estate analysis and strategy development. Just a couple things to note. Obviously, a lot of things are in flux as a result of COVID, including our own space needs and what might happen with tenants. I guess on a positive note, and I don't know if John will be giving an update later, but we did have some interest in a tenant. So that was good news. We also directed staff to start the process for looking at refinancing our 2012 B of A loans so that we can bring that back to the board in September. There's an opportunity to significantly reduce our cash outlays given where interest rates are. So it makes sense to look at that. We also reviewed the metrics. We reviewed metrics that are not met. It was not a lengthy discussion. We'll have a more lengthy look at the ones that they did meet at our next call. I guess the bigger issue, and one that you should all be aware of, is that we did not get to review financials. And we do not actually have Q1 financials yet. As you know, the bar transitioned to a new financial system, and as of yet, they have not been able to generate financial reports. So that's clearly not a place we're happy about being. We've asked the staff to try and construct something that may not be official financials that we can review, but something to at least give us some indication of where we are. The biggest, when you go to a new system, there was a lot of moving parts. So we don't need to go into the here and now, the whys and wherefores as to why this happened. We have discussed that, but it does put the bar in a difficult situation in that we don't know exactly where we stand relative to our financials, particularly with payroll and personnel. So we've asked them to at least try and come up with some way of reporting at least the key pieces of it that we can look at and get a sense of where we are. So I believe that at this point, the reports are expected the week of the 27th, which is a week after next, I believe. Review them immediately, but for that reason, we will not be reviewing financials today.
Well, the deliverables on July 27th, is that just quarter or both first and second quarter?
Probably first. I'm going to assume that they haven't closed the books, but John would have to answer that.
Okay.
On Q2. So it's.
I agree, Renee. I don't think we've closed books on Q2 just yet.
Questions for Ms. LeBron?
Mm-hmm.
All right. Audit Committee, Mr. Pertula, anything to report?
Thank you, Mr. Chair. No report at this time.
All right, thank you. All right, then that concludes the reports from committees. We can move on to item 700, miscellaneous, and the first agenda item is 701, consideration of recommendations to implement changes to address key findings on the disparities in the discipline system. And I understand that Mr. McLeod and Professor Robertson will be reporting on this.
Thank you, Chair Steinbrecher. I'm going to ask staff to promote Professor Robertson, Christopher Robertson, from the attendees so that he can present. I'm going to give a brief introduction to Professor Robertson's presentation. As we've already heard earlier today, in November, the Board of Trustees heard a report from Professor George Farkas of the University of California at Irvine. The report took a rigorous look at disparities in the discipline system, specifically looking at the racial and ethnic differences in the rates of disbarment and the rates of suspension and assignment of probation for attorneys in the discipline system. While the study found that there were disparities, it also, by looking deeper and looking at other variables related to the discipline system, found a number of variables that were associated with the race ethnicity of the respondents in the discipline system. Specifically, the statistical analysis identified that African-American men in particular had more complaints filed against them. So the very inputs that came into the discipline system at the outset were already stacking the deck somewhat against African-American men. The other issue that the statistical analysis found is that African-American men were much less likely to be represented by counsel when investigated by the Chief Trial Counsel's office. To respond to this report in November, State Bar staff identified a scholar who has a relevant background in the area of organizational behavior and elimination of bias, Professor Christopher Robertson. We reached out to Professor Robertson, and Professor Robertson took a look at the study, conducted a preliminary analysis, and returned to the Board of Trustees at the January planning meeting, at which time he presented a menu of options, some alternatives for additional research that might be conducted. Since that time, we've been working closely with Professor Robertson to return to the Board of Trustees at your direction and to provide additional recommendations and more specific proposals related to this, this item. I have had the tremendous pleasure of working with Professor Robertson, who has been both thoughtful and thorough and creative in addressing this important and timely topic. Professor Robertson is currently the N. Neil Pike Scholar and Professor of Law at the School of Law at Boston University. He is also the Visiting Scholar and Special Advisor at the James E. Rogers College of Law at the University of Arizona. I'm going to turn it over to Professor Robertson to present before we then look at the specific recommendations from this item. And Professor Robertson, you should have the opportunity to share your screen. I understand you have a PowerPoint presentation that you're going to be presenting along with this. So with no further ado.
Yes, thank you so much. It's really been my honor to support this decision-making process and provide some ideas that can go into it. And so let me just, without ado, confirm you can hear me and see my screen share.
I can.
Great. So just a word about myself. You know, I've been working for over a decade on a range of questions about how to manage decision-making in institutional contexts to minimize bias. And this approach really reflects a mix of scientific fields, including economics and psychology, and a broader field called judgment and decision-making. And so we look for areas where the institutional context and the information presented might create biases. But I want to emphasize that doing so does not necessarily implicate that any individual person is prejudiced or biased in their decision-making. But we see nonetheless institutional or systematic or structural disparities emerge when those biases are not properly mitigated. And I also bring some perspective from the related field, the other professions in health, like the profession of medicine, who've confronted some of these same issues and problems. So let me just say that I'm here really for your benefit. Hopefully I can be helpful in making this presentation, but I'd welcome you to speak up and interrupt me. Think of my presentation as a scaffold for your own questions or comments. I'm just going to walk through each part of the report, but you have it in writing. And I'll try to do so rather quickly. So my background and process has been to really take the 2019 report by Dr. Farkas kind of at face value. His report did what it did and found what it found. I've tried to interpret it and understand what it means in context. And in doing so, I've interviewed and surveyed people both within OCTC, attorneys from the staff level doing the intake all the way to the leadership of OCTC and the State Bar. I've also done surveys of other jurisdictions and law professors in a range of fields, and then also done some of my own research, both on the scientific questions about how bias can get in decision making, as well as what might be called scholarly legal research. In this setting, I should emphasize nothing I'm saying is a legal opinion, and you should get your own lawyer's advice. But I have brought the law professor's eye to areas where I see sort of the broader policy context for the work. And finally, I've provided drafts of my work really for the last month and a half or 2 months and gotten feedback on it, and then done revisions, but really in my own independent judgment. So the work really does reflect my own view. I did want to emphasize 4 things I haven't done is I haven't had the chance to do my own statistical analyses of the discipline data. I mean, you know that in producing a report like Dr. Farkas produced, sort of many decisions are made along the way as to how to structure the data and how to structure the models. And I actually think another pass through that report, as I'll recommend at the end, another pass through that data could produce additional insights. I also haven't done the degree of stakeholder engagement that I think would be appropriate. I've done as much as time is permitted during this process and sort of a back and forth, early ideas, talk to some people, develop my ideas, talk to some more people. But, you know, I haven't had the chance to talk to significant numbers of Black male attorneys in California, or people that have actually gone through the discipline process, or others in that manner, though, as much as would be ideal. We haven't also done what I would call detailed feasibility testing. You know, I talk about archiving old complaints, but I haven't personally investigated whether that's even feasible in the case tracking system. And finally, we could do some data work, modeling or pilot testing the impacts of various reforms. Those haven't been done either. Instead, what I've tried to generate is the ideas where if we wanted to focus that work on a particular potential reform, I'm at least putting it on the table to do so. And then it's really up to the Board of Trustees and the staff to determine how much more research needs to be done or whether something is facially plausible just to go ahead and do it. And I leave that to you. Okay, so 3 focal areas of interest that jumped out at me as I read the Farkas report over and over are client trust funds and disciplinary complaints around them, how OCTC considers prior complaints when they're deciding what to do with a new complaint, and third, whether attorneys are represented as they go through the discipline process. And I selected these focal areas both because it's areas where there's a large racial disparity and because I suspect they might be important for the ultimate outcomes of disbarment or probation. Before going forward, let me also just say that I'm focusing mostly on Black attorneys, and I'm not going to spend time today reviewing the Farkas report or refreshing your memory as to what it showed, other than to say that it looked at gender and it looked at race and it even looked at practice areas. But what really jumped out, the largest disparities were for Black male attorneys that were disbarred at, as I recall, 3.8 times the rate of white male attorneys before other things were controlled for. When I say before other things are controlled for, we could do a whole hour lecture on how to interpret a multivariate regression model when you're dealing with things like race, which is an immutable characteristic. For my purposes, the mere fact that the other things are controlled for provides a sort of strategy of things to focus on in reforms. Okay, enough throat clearing then. Moving to client trust funds in particular, this is the case type that Dr. Farkas found had the largest disproportionality. By that I mean Black male attorneys had problems coming into the state bar at a greater rate than would be predicted by their mere numbers. And so this is generated by a statutory reporting requirement that creates these things we call a bank reportable action. The California statute requires that whenever a trust fund account crosses the line from positive to negative, when it goes below 0, the bank must issue one of these notices to the California State Bar, and the California State Bar receives a couple thousand of these per year. So this is a high frequency sort of complaint, and it also is one where there's a large racial disparity. And notice this is a disparity coming into OCTC, right? This is before OCTC has done anything with a particular attorney. When you think about the potential causes, there are 3 primary ones I focus on that could create a bank RA. One is just being in a practice area or a practice setting, like a small firm where you lack support, where you don't have a bookkeeper or an accountant or a good technological solution. Or maybe the practice areas have so many transactions. If you're clearing 1,000 checks through trust funds a year, you're going to have more chances to have a bank RA than if you're in a practice, you know, doing mergers and acquisitions for a huge, one huge client at a huge firm. There's also a huge systematic and radical wealth disparity in the United States and in California by race. And I hypothesize, this is really a hypothesis, but it's something that the bar could test with its own data, that Black male attorneys are systematically managing trust funds with smaller balances. And so if you have a smaller balance, you're more likely to bounce a check. Probably everyone on this call was once a poor college student, or at some point in our lives, really had to count every penny to make sure a check cleared. And then at another point in your life, you've got a little cushion where you don't have to worry as much. And if there's a small hiccup, it just works itself out over the next few weeks. So this is the same sort of concept for client trust funds. If there is a disparity, it's simply in the amount of money. You could have attorneys with equal levels of professionalism, nonetheless having different rates of bank RAs. Okay, so that's the background. I suggest two groups of potential reforms, and here some of them are what I call downstream. They happen after the case reaches OCTC, and one is upstream with regard to how the cases from happening in the first place. Okay, so the first of these potential reforms is to think about what OCTC already calls a de minimis closing. For many of the cases that come in, if it's just, say, a $25 overcharge, if the balance on the trust fund goes down to merely negative $25, OCT will close those cases with what they call a de minimis closing and not actually even investigate them. My research was not able to, and so they're currently using a $50 threshold, and some of the guidance within their policy manual suggests that the attorney must have 0 prior bank RA cases, although in my discussions it's not clear how strictly that's applied. But my suggestion here is we could raise that threshold, maybe as high as, say, $500, and that alone would dramatically reduce the number of times Black male attorneys, I hypothesize, would even have contact with OCTC. Again, the effect of this could be modeled if we looked at past data regarding complaints to see really where to set that threshold and how much of a difference it might make. So the second potential reform in this area is to allow, to clarify its current rules, to allow attorneys to actually put some of their own money or their firm's money in client trust funds accounts to sort of serve as a cushion. State bar rules, I mean, this is technically considered commingling, which is, a very bad thing for attorneys to do, except we already have an exception for that, to commingle funds to allow the payment of bank charges. This would be like a sister provision to that idea. And it's actually implicit in what attorneys already do in commingling multiple clients' funds in an IOLTA account. So we have a concept for having funds from multiple sources in the same account, and I think this could allow attorneys to avoid that problem of merely having too small of balances. And incidentally, by the way, that Reform 1.2 would create more systematically higher balances in IOLTA accounts, which would then come back to interest payments that support the access to justice mission of the bar. It would also make it safer for attorneys to serve clients with smaller balances in trust fund accounts without always being at the risk of a check not clearing. A third potential reform is to change some guidance that I found in some manuals and CLE programs of the state bar, which currently really emphasizes, based on some California Supreme Court precedent, that this is a non-delegable individual duty. And here I draw on the literature and the experience of the healthcare field and think about how they prevent medical errors by adopting what's really a systems-based approach. And so if I was to advise a young attorney, I would say, John, the first thing you need to do is to put together a system for your client trust fund accounting. And that's different advice than if I said, John, don't worry about a system. It's a non-delegable duty. You need to do it personally. And I think we can just become a little more realistic and foresightful about that guidance. And that's one piece of really a broader culture change, I think, is the way we should think about this problem. And then finally, it's really astounding as I looked into this field. I don't have a client trust fund account. My practice area before I became a professor didn't involve me directly doing this sort of work. And I was really astounded to find that many attorneys, there's not really a turnkey solution for how to do it. And I think that's partly some sort of old-fashioned legalism that in many ways the legal field has been a little slower to adopt online banking and other sort of compelling solutions. My thought is this should arise in the private market already, but it hasn't, and I think the California State Bar could facilitate that. And there's already some partial solutions, like there's a trust book software, and of course you can hire a bookkeeper. But especially for individuals, solos, small firms, we really want to grease the skids, make it as easy as possible for people to get the kind of services they need. And this might also work with California Lawyers Association, might be the key actor rather than the State Bar itself. I'm quite aware of the regulatory separation of the bars. Okay, that's all I have to say about client trust funds. I'm trying to move expeditiously. Let me take a questions, if any.
Yeah, excuse me, Professor. Just a quick question. Did you say you don't have any data? Like, do you know how many of these cases happen per year and how many were, it sounded like you didn't have really any idea of the order of magnitude.
I do have an order. I was able to draw from the annual disciplinary report to say that the State Bar receives about 2,000 of these bank RA reports per year. And OCTC files about 100 such cases in State Bar Court, and that yields about 55 closures with discipline annually. But few of those are probably disbarments, and that's the piece we haven't yet really modeled out, is that link between this particular case type and disbarments. This case type was shown in one of Dr. Farkas's tables, but it's not in his ultimate regressions. And so what I don't have is the causal effect on disbarments.
Yeah,
that would actually be pretty tricky to model anyway, because what we see is, attorneys accumulating problems over a career. And so linking any disbarment to a particular problem is harder to do.
Got it. Thank you.
Professor Robertson, this is Ruben Duran. I have a follow-up question on that.
Yes, sir.
You mentioned 55 incidents of discipline per 100 of these cases that make their way through. I think that's what I heard you say. Do you know how much of that discipline involves specific actions or requirements related to client trust fund accounting?
No. Those are just disciplines that's related to those cases that were filed. So I haven't done that sort of granular review, and it isn't, at least I couldn't find it in any bar reports.
Okay, thank you.
I'd like to jump in just for a moment. Brandon, if I may, just a point on the data. We have had some conversations regarding these numbers as a result of Professor Robertson's reports. And although I think it's important and valuable to have that order of magnitude number, roughly 2,000 a year, what we need to also be aware of is that there are often challenges with regard to counting numbers of cases versus numbers of attorneys. And then when allegations are actually filed, when you get to the 55 number where like a case may have actually been filed, understanding like what role the reportable action bank matter might have had in that is also a tricky thing that we're going to need to tease out going forward. So I think Professor Robertson was appropriately cautious with regard to his comments about what we really know about the actual numbers. I would simply like to emphasize and sort of re-emphasize that caution that he exercised. And I apologize, I interrupted you, Trustee Stallings.
And I guess, Dag, you can jump in on this as well. But one of the things that we've talked about in our some of our preliminary meetings is that this RA issue is in some respects a canary in the coal mine situation where it could alert the bar to some sort of issue with the lawyer that could be prevented. And there's kind of a tie-in with proposal 2.3 as far as coming up with preventative models. But could you just break out a little bit for the board, the importance of having kind of that indicator of potential misconduct or something that could lead to damaging more clients if that lawyer is deficient in their client trust account?
Sure. And this is something I've talked to OCTC about at some length, and I cite some of the cases in the footnotes as well, where People have been disbarred, and the Supreme Court has disbarred people because of something that originally began in this way. I haven't actually used the term, and I should say so explicitly, that, you know, one of the causes of a bank RA could be misappropriation, right? If the attorney steals funds from their client, or it could be gross negligence, or, you know, extreme recklessness in handling client funds. And of course, as we know from attorney discipline more generally, these things are often linked with other problems, right? You know, substance abuse or something else can sort of echo into all sorts of other problems. So that's why 1.1 here really builds on a practice that OCT is already doing, though, and recognizes that these small, isolated, rare instances are unlikely to be misappropriation or gross negligence. And so 1.1 is really just tinkering with the thresholds of this concept that's already there, right? People aren't typically stealing $50, but they're probably not typically stealing $250 from their client and putting their license on the line. And so finding that threshold is just the question.
And then as to the threshold issue, is that amount set by statute or is it an internal policy?
It's even less than an internal policy. It's like an internal guidance in a worker manual. So it's one of the weaker forms of internal policy, I would say.
All right, thank you.
This is Debbie. This is Trustee Debbie Manning. On that
Hi.
On that 1.1, I like what you're saying about, can you hear me?
Yes.
Yes.
Okay. I like what you're saying about raising the threshold, because I agree with you when you say people aren't going to put their license on the line for a $50 overdraft or even $250 overdraft. You know, it just happens with those smaller amounts. And raising that threshold, I think, would be a good idea. I know we have had some comments earlier today from organizations that have said that, you know, they agree with this as well. So I like that. Thank you.
Thank you. I'll keep moving forward if there's nothing else right now. Okay, so the next big area was consideration of prior complaints. And by that I mean how OCTC, when they have a new complaint, what you might call an index complaint, in July 2020, do they, in deciding how to handle that complaint, do they look back at the attorney's history of prior complaints? And the problem here is that black males get more public complaints, and we don't necessarily know why they get more public complaints. It's probably one of these problems that's sort of all of the above. It probably involves them working in practice areas that have greater engagement with more members of the public. It might involve them being in more contentious practice areas where the public has a bad outcome, even from the professional attorney. If they have something, if they're upset about something, they might be more likely to file a complaint. It might also involve implicit or explicit racism by some members of the public. And it's remarkable, the literature is actually quite strong in showing a range of contexts where blacks and other groups are subject to racialized decision-making. And the decision to file a complaint could be exactly that sort of racialized decision-making. So Dr. Farkas also found that the more prior complaints you got, the more likely you were to be disbarred. And of course, that could be because really bad attorneys get more complaints, but it could also be an echo chamber phenomenon, that record of prior complaints is causing even good attorneys or decent attorneys to be burdened by them and lead to greater problems. And so here again, this is all happening. These prior complaints are coming in the door, and of course OCTC can't control what comes in the door, or it couldn't decide just to ignore things that come into the door. But I suggest the way it handles prior complaints should treat them as if they were infected by a risk of bias. It should worry about a prior complaint, especially where it's looked at the complaint and determined that it's more or less frivolous and not worthy of investigation, or if investigated, it's not worthy of discipline. In that leftover category, those residual complaints are the ones that lack probative value, arguably, but are likely infected by either cognitive bias or systemic institutional biases. And so here I really draw from the state bar court's rules that already say that mere closed complaints that are closed without discipline actually lack probative value. So an OCTC attorney would never say, disbar this guy because although in this case, he did X, you should really, consider that we had 10 prior complaints that we closed without discipline. That would not be allowed under the current rules. And so my proposal is that we should really think about whether the state bar attorneys, the OCTC attorneys, consider those prior complaints. And again, here I looked at some of the internal guidance manuals. I interviewed and did a focus group with 2 other consultants to try to figure out how are they using prior complaints. And it's not, frankly, patently clear. There may actually be some variation between individual attorneys. So rather than lingering on what's currently happening, I do suggest some reforms, both downstream and upstream, really to make sure that OCTC is able to really protect its integrity from the sort of potential bias that's coming in the front door. And so here again, I've suggested a range of complaints. The first is to suggest that older complaints could literally be expunged. This reflects really a nationwide trend that California is on the forefront of in the criminal law sector. Expunging prior arrests analogously, and even expunging some prior convictions for low-level conduct, where those are similarly racially disparate. And here again, get your own legal advice. This is not what I was hired to do, but as I looked at, is to give you legal advice, but when I looked at guidance from the California Supreme Court and the legislature statute, it does appear that the state bar may have, under current law and under current guidance, the ability to expunge at least some older closed complaints. And so I'm putting it on the table for you to decide whether to actually do so. The second reform is, and this could be independent of 2.1, or it could exist even if you don't do 2.1, you might consider doing 2.2. Really either way, there'll remain these more recent complaints that you could consider archiving. The reason I'm using the word archive here instead of expunge is I think OCTC has persuaded me that in some cases they actually do need to go back and look at other complaints that were closed, at least the ones more recently within the last few years. One reason for this is that if a complaining witness calls in, they might be intending to give additional information about an old complaint, or they might do so by simply filing a new complaint. And even to make sense of it, you sort of need to cobble together the record that might be stored in different complaints, even though they involve the same course of action. So I suggest some ways to do that to make sure that we're not just routinely looking at them as if we were judging whether the attorney is a good guy or a bad guy merely because he's gotten these prior complaints. The third and final major reform in this area is to suggest, maybe if there is a role for looking at old complaints, but it should be non-disciplinary. We do want to be able to connect the dots, and there was a recent audit of another agency that faulted the agency for sort of not connecting the dots of individual complaints. And so to the extent that you want to have a proactive non-disciplinary system, prior complaints could go into that system instead of becoming sort of a ding on the attorney's record. And this recommendation really connects to the work of another task force, the Governance and the Public Interest Task Force, which spent the spring looking at a similar approach. I'll pause there.
Professor Robertson, this is Brandon Stallings. So one of the things that's been discussed at the board level is this idea of self-diagnostic tools and the utilization of such methods to demonstrate to a lawyer what he or she doesn't know going into a particular practice area, and highlight areas where an individual might seek that information and then avoid common mistakes. Is that something that you think could apply to 2.3? And if so, how could we implement it in a way that's most effective?
Yeah, I mean, I did 2.3 here really to provide a vehicle for using old complaints. I'd say if you want to use old complaints, use them in this way. So it's a little, its motivation is a little different than what you're suggesting. But yes, I think the mechanism you're talking about could be part of that proactive non-disciplinary system. The only asterisk I would put on it is that a lot of what we've done in attorney discipline over the last century has been really focused on this idea that if we could only educate you, maybe you'd avoid discipline. And the model that attorney discipline is about being ignorant, that like if you don't have the information you need, I think is a little bit old-fashioned and probably doesn't reflect what we often know in the behavioral sciences about what really drives behavior. Having information is necessary to succeed in some settings, but when we fail to succeed, it's often not due to mere lack of information. It's often due to mere lack of support. And so when we talk to an attorney that had a bank reportable error, you know, they might well know that they should balance their checkbook every week, but you know, there's various other situational facts that prevent them from doing so. So yes, I think that's a good approach, but it's only one piece of the pie.
This is Trustee Manning. The expungement and the archive, I think, to me, have some level of merit because there are a lot of complaints, like we just talked about earlier, the client account complaints that just sort of pile up and they're like $50 here, $250 there, whatever. But then you've got all these prior complaints. And so, you know, like that adds up into something, even if it's not probative. I think that still people in their mind will think, yeah, there's something going on here. So we're going to perhaps discipline you a little bit more harshly because we think there must be something. We can't totally find it out, but we're going to discipline you anyway. And so I really kind of like exploring those a little bit more about the expungement and the archive. We've been dealing lately with some things where people have been several years old, complaints that have been several years old, and now they're being disciplined for them now, and some of them longer than 5 years ago. So it is something I think that from a consumer standpoint, public standpoint, I would like to see explored a little bit more deeply.
Thank you. I will move forward to the third category. If there's nothing else at the moment, you can always revisit these at the end. So that's representation of attorneys. And here again, black males were dramatically less likely to have an attorney as they go through the bar disciplinary process compared to white males, Dr. Farkas found. You know, you can't help but say, gosh, they are attorneys. Of course they are attorneys, but these are very specialized areas, right? Merely because someone's a physician doesn't mean that they can, you know, do surgery on their own leg. And the same is true, I think, of an attorney. This is a very obscure practice area and requires a level of expertise. And then, frankly, it also requires an arm's length evaluation of your own case to overcome optimism and overconfidence biases. So there's lots of reasons I think that attorneys can make a difference here. Dr. Farkas also then found, sure enough, that if you are represented, you'll hear the relationship was negative. Representation predicts not being disbarred. It does seem to make a difference, and my theories are that difference might well be causal for the reasons I suggested. So why do we see attorneys not getting represented? I think there's probably two big categories of reasons. One is what we might call decision making. They might not realize how complex this area is and how important it is to have attorneys represent them. They might also be biased in their own assessment of their case and in their own abilities to represent themselves. And second, probably even more important, is just affordability. The attorneys that are facing disbarment are often having other economic problems that make it challenging. And of course, you know, as as one of the comments suggested earlier today, the cost of going through the discipline process can be expensive in terms of fees and expenses, even aside from getting your own attorney. And so they do add up. So two categories of reforms that I suggest. One, group is to see if we can increase the rates of representation. Since if we create policies that do so, hopefully Black males will disproportionately benefit from them, since they're disproportionately unrepresented currently. But I think any realistic appraisal of the way the world works, unless you're going to go all the way to a public defender system, you'll end up with some still not represented. And so I suggest some reforms that could also improve the outcomes even for those that remain unrepresented. So the reforms I suggest here are, first, that we need to start thinking about the rate of representation as itself a performance metric, and we should start tracking it longitudinally. That'll get essentially a scorecard that we can measure the success of the other reforms, I suggest. The second one is, the state bar currently does inform attorneys that they could and should get represented. But I'm suggesting more of a marketing-based approach, really, a behavioral approach, to ensure that they know that it makes a big difference. And I think the Farkas report is sort of exhibit A, and we should think about how to distill it down to a single statistic that really communicates to the attorney that facing cases like this, you're dramatically more likely to get disbarred if you don't get an attorney. I'm not sure if people recognize that. And the third is to develop a roster of attorneys who can provide these pro bono, at least 1 hour consultations. And the advantage of keeping it short to 1 hour is we don't have to go through an extensive means testing process to figure out who's worthy of that cheaper rate. Because you could spend more than an hour figuring out, sorting the wheat versus the chaff of how poor is an attorney really, before you'd even provide the pro bono service. So the idea here is to provide it to anyone that wants it, but you keep it short. My suggestion is that might be enough to at least give people a more realistic sense of their case and the sort of work that would be required to adequately represent themselves. And then, frankly, some of those will then convert to actual representation paid. So this is based on a model that's used in Arizona already, and one that I've had some stakeholder discussions, and others have proceeded even without me to start fleshing out what this looks like. And linking 3.2 and 3.3, I suggest doing more than just giving people a roster. Here's 100 attorneys you could go talk to that'll give you a pro bono consultation. Behavioral science suggests you want to give them a very specific thing they could do today. And so I suggest actually curating that list to maybe geographical areas, and even randomly selecting from that list to recommend, here, call this particular attorney today. Going further, though, there'll still be some that need more extensive representation but can't afford it. And so I suggest the state bar can facilitate a sliding scale fee representation, so that maybe attorneys making less than $100,000 could get represented at say, half price. The bar, the California bar that represents attorneys in these areas, charges going rates. Some of them charge $700 or more. And so there's a real cost here. But my preliminary conversation suggests a willingness to provide sliding scale fee representation if the state bar would provide that means testing. So the state bar would be the one that receives the tax returns or other information and certifies, okay, here's your voucher for 50% off or 25% off or 75% off. And you take this voucher to a member of the defense bar who's agreed to accept it. And finally, sort of a wraparound entity that I'm calling for now, a discipline equity office, could be created. So just starting with maybe a 1.0 FTE plus some additional support. I'm saying that verbally, it's not in the report. But the idea is that someone could really be working to ensure that attorneys sort of put their best foot forward in the discipline process, minimizing disparities. And in the report, I cite models. The IRS has a taxpayer advocate. The California state courts have self-represented litigant centers. And there's other sorts of examples of ombudspersons. that really exists to provide one centralized place to support people going through an adversarial process. I'll pause there. And I do have some wrap-up comments that I'd like to have a chance to make. But anything on representation?
Yes, Professor Robinson, Brandon Stallings. Could you speak a little bit to what OCTC is currently doing in regards to contact with pro per litigants, as well as requests for information regarding mitigating evidence, mitigating information that could be used at the early the evaluation process at the very beginning, and I guess what impact that had on your recommendations?
In my research, I didn't find a systematic approach to this question. So, and I don't think I've had I didn't have a focus group or extensive interviews on that particular question. So, but my knowledge is that they send at a couple different points, and they do send a letter that includes an advisory to get representation. But my sense is that it's sort of a legally formalistic advisory more than a one really designed to change the behavior of the attorneys facing discipline. And so I think OCTC might be able to speak more directly to answer your question. That's sort of all I have.
So, Mr. Chair, I don't know if we could direct that question to any of the OCTC staff that's on the line now, or reserve that for later on in the presentation.
Let's reserve that for later on in the presentation. Thank you.
Thanks.
And I'll just mention sort of institutionally, I think there's one reason I'm thinking of creating this discipline equity office is that, you know, to some degree, and I think to a large degree, the attorney discipline process is adversarial, and that, you know, in the great American tradition of litigation, adversarialism can work. But I think it's a challenge to ask OCTC to, while having one side in that, sort of as prosecutors, to nonetheless also be supporting the adversary. And so my hope is through this discipline equity office might provide a more systematic place to do that work. And one other analogy I'll mention, so I mentioned prosecutors, is you know, criminal prosecutors have in recent years also been creating offices within their agency to sort of fight wrongful convictions, for example, that is in some ways analogous to. So in my next steps, I do have a last part of my report that is not really just pro forma. I really do want to emphasize that, you know, in addition to these 12 reforms, which you might say need more study, or you might want to go a little more faster to adopt some of the low-hanging fruit, there are other hotspots in the Farkas report that I just haven't gotten to out of a sheer sense of time that might well be as important or more important than the things I've already done. Third, that there really are some other empirical approaches beyond the Farkas report. I was really struck, for example, that the main regressions don't include criminal convictions as one of the factors, but yet we know in America and California, you know, the criminal justice system has huge racial disproportionalities. And so if that is then causing people to be disbarred because they got a conviction, then that I have a huge hypothesis there that we need to look a lot more closely at that, for example. And finally, in January, I flagged two other approaches. One is to look at the staff diversity within OCTC. And I understand there's some ongoing work to get that data. In January, I also suggested there might be places to do blind review so that at least some people within OCTC can either make initial decisions or review decisions without being exposed to the race or the name, which can be a proxy for race of the defendant or the responding attorney. So that really wraps up what I have for you today, though I'm here for your questions or comments as long as I can be. Thank you so much.
Robertson, thank you very much for your work on this. This was a terrific report, and we really appreciate the issues that you've raised and the suggestions you've made. This is an important step for us, and you have contributed to it significantly, and we thank you very much.
Thank you.
Again, thank you. Now, are there questions for Professor Robertson?
I have a quick comment / question. I would like to, I'm sorry we didn't have more time to talk about some of the blinding, and I would just encourage us to really pursue that. I think this has come up before in this meeting, but I've done work, been around work for that in another setting with Iris Bonet, who you probably know through this work, and she has really done a remarkable job looking at the impact of that, and just the impact when people review resumes. I mean, it's another place, you know, we should be looking at that throughout the organization. The impact when you review resumes and judgments people make about names, whether you don't know if they're male or female, people make assumptions about ethnicity. But it's really quite impactful when you look at the data on that. And of course, the most famous case is when it was when they stopped doing orchestral tryouts on a stage, and they put up a curtain so no one could see who it was, and it changed the composition of the orchestra. So just would like to encourage us to really pursue that. It's a very easy fix that has had significant impact in other organizations.
Okay, thank you. Other comments or questions for Professor Robertson?
Jump in real quick, Alan?
Yes, Chris. Iglesias.
Thanks, Professor Robertson. I mean, I think the world has definitely changed since you presented to us back in November. I think that was my first meeting. And, you know, I think the recommendations are good and everything, but I think right now, the state bar, all of us, I think we have a green light to really look at all of this, you know, equity issues much differently now, right? I mean, we could talk about it differently. We need to talk about it differently. And I think the recommendations, I don't know, I think we need to be bolder on this. We need to let Black attorneys know that we stand with them, you know, that we're not just here to whack them, right? I mean, they've been fighting discriminatory practices for years, right? You said it, like, you know, most of these attorneys, they do a lot of public work, right? Because they get a fair shot at doing public work. They can't break into a lot of the private sector work, right? And the tech work or whatever, right? It's like all the bro work, right? So these are huge issues that I think right now we have an opportunity to look at really, really boldly and to make some really bold decisions or bold ideas on how we kind of just not reverse this discrimination, but really just look at how we practice, how we discipline folks. So I really like the equity office, not just necessarily in the office of the chief trial counsel, but just in general, maybe for the state bar. But I think we really have to take a hard look. And I just, you know, I don't know if you even have any really crazy ideas that you want to throw out right now, but I think I would just invite our other trustees that, like, you know, the issue of race right now in the country is front and center. When you look at what's happening with the pandemic, pandemic's basically a Black and Latino disease. That's who it's infecting. That's who it's killing. You know, and then with the George Floyd, I just think we have just a green light to really discuss these things on a whole different level now. So, and I would invite the other trustees to think that. And I'm just wondering if there are other like crazy ideas that you might have that you wouldn't have said back in November, but you definitely want to say now. So that's all I'm kind of throwing out.
Thank you. I mean, I can't emphasize enough, I think, the importance of what you're saying. And I will say radicalness is in the eye of the beholder, right? So some of the ideas that are in this report are viewed by some people as radical, and some of the others might be more doable. So to go further in one direction, I mean, expunging old complaints, for example, I think is exciting. This is actually that sort of thing. Expunging old arrests is actually the tip of the spear for reform in criminal justice around race. And so I think that's an example of something that is in accordance with the time. And frankly, that was not in my draft report back in May, but it is in my draft report now. So in part, I actually do think it is responsive in the way you've suggested. You know, if you want another radical idea, is you could create a public defender system for attorneys. That is one place that I stopped short in this report. Of course, there's no constitutional right to representation in this sort of case due to the line of cases going back to Gideon. But if anybody recognized the importance of having representation, it might be the state bar itself. And so you could at least commit to representing your members when they face discipline. Of course, that has financial implications. And frankly, one reason I didn't go there is it could be a very poor panacea. If you created a public defender system but didn't appropriately fund it, which we've seen in many places where public defenders are funded at a fraction of what prosecutors are funded, you might not actually get the outcomes you're hoping for. But that's an example of me, looking in the direction, I think, of more radicalness, but not going there for good reason.
Thank you.
Thank you, Chris. Other comments from any board members or questions, particularly for Professor Robertson?
Just quickly, I know we have a lot to do today. Do you know what percentage of the disciplined attorneys are unrepresented? And maybe if there's a split between the Black attorneys and non-Black attorneys who are unrepresented. And it seems to me that you're actually advocating for some form of a referral service, which I don't know that the bar could get into, but I mean, it does lend itself to that kind of a model for attorneys who could ill afford to hire their own or don't know where to go. So maybe just those two things.
So I don't have the percent in front of me of attorneys that lack representation. Dr. McLeod may have that, but there is a disparity in Black attorneys. As I recall, they were about half as likely to be represented. On the lawyer referral service, I did look into that a bit, tried to do a little bit of research on what the state law says about attorney referral services. And again, get your own legal counsel to advise you, but my reading of it suggests that if you're referring for pro bono services, it's not applicable to the state statute. And so since what I'm proposing here is that 1 hour pro bono service, then you're not technically a referral service under the state law. But again, your mileage may vary when you get your own legal counsel.
The figure is approximately 16% of African-American attorneys indicated, our data show that they were not represented by counsel when they were going through the state bar discipline process. And that compares with right around 8% of white attorneys who were going through the discipline process without counsel.
Thank you.
Any other questions for Professor Robertson? Well, Professor Robertson, again, thank you very much. You've been tremendously helpful, and you've helped us move this forward tremendously. So again, thank you. You're certainly welcome to stay on the line, but if you have to go, you'll understand.
And let me thank you for your time, and thank the Office of Chief Trial Counsel for being incredibly open and gracious and engaging with me through this whole process. And it's been a pleasure to work with them and the whole team here at the California State Bar.
Thank you.
Thank you.
All right, let's turn the discussion now to the board. One question I would like to ask Dag or Donna or whoever you choose to speak is we have a list of recommendations in the two resolutions before us in item 701. And to Chris Iglesias's point, these may not be as aggressive in all areas as some people may want. So I would just like to know what was the thought process that went behind deciding how to come up with these particular recommendations.
Donna, do you mind if I take the first crack at that?
Go right ahead, Doug.
So I think this may sound a tiny bit off point and a tiny bit contrarian, but let me say one thing, and it will tie back to this question of why we came up with the recommendations that we came up with. Well, I'll point out something that Professor Robertson notes in his report and that is also in the staff report, which is that an indication of disproportionality doesn't speak to the underlying issue of whether a miscarriage of justice has occurred. Now, I agree with all of the comments that have been made about the moment that we're in and about what we understand about the broader socio-political environment of our country and the legacy of historical racism. But I think we might do well to look at the actual cases of discipline that form the foundation of the statistical report, because it's also possible that disproportionality, what we're seeing is privilege in the opposite direction, that perhaps it's very difficult to prosecute attorneys generally, and it's more difficult to prosecute white attorneys. And so perhaps the recommendations could go in the exact opposite direction in terms of saying, you know what, it needs to be easier for OCTC to secure convictions of attorneys who have engaged in misconduct. Perhaps it's the African Americans who have suffered from not being able to defend their cases as well as white attorneys. So I offer that note of caution because I do struggle a little bit with the underlying finding and just my own observations of the work that OCTC does and the caution that they exercise in their work. And I think we have a relatively, because the number of African American attorneys practicing in the state is so small to begin with, which is itself an indication of part of the problem. The number of attorneys who've been disciplined that form the basis of the statistical analysis is itself rather small. So I think something under 100 attorneys over the last couple of decades who have been disbarred or suspended that form this core of African American attorneys who were disciplined. So it might be something for Office of Research and Institutional Accountability to look into in terms of evaluating these cases themselves and just ensuring that there was not a miscarriage of justice in regard to these specific cases. Because if there wasn't, it suggests to me that perhaps the disproportionality runs in the opposite direction, that perhaps there are white attorneys who should have been disciplined who were not disciplined. And returning then to the specific question, I think that that's partly where I'm coming from in terms of the staff report and why the recommendations were not more bold or radical. I think that there is a fair amount of data work and there are some underlying questions with regard to the cases that I think we would benefit from knowing the answers to.
All right, thank you. Mr. Stallings, you had a question for OCTC, and this may be an appropriate time to pose that question to probably Ms. Lawrence if it's still topical for you.
I think it is. Melanie, can you just talk a little bit about what OCTC currently does in regards to sending out letters advising of the pitfalls of self-representation and then requests for mitigating information at the ENEC stage?
Can you hear me?
Yes.
Okay, great, thanks. So we do communicate with the respondent attorney throughout the investigation process. And once a case moves forward to a pre-filing stage, so the investigation is done, we send respondent attorneys a letter telling them that the case has in fact moved forward and asking them to provide any evidence they have in mitigation. And we don't specifically tell people in letter form about representation or encourage representation. We do, however, our attorneys do regularly talk with respondent attorneys about the fact that there are experts out there in the area of disciplinary law and suggest that they might want to talk with somebody. When we get to the early neutral evaluation conference stage and send out a letter to them inviting them to participate, we again invite them to submit evidence and mitigation. And I think the court also does that in their notice to the parties related to the setting of an early neutral evaluation conference. So we make several attempts to get the evidence because it's very meaningful for us in terms of determining what the appropriate level of discipline should be.
Thank you.
I got from that you really don't advise them too much about the greater chance of success if they were to hire an attorney. Is that right?
That's correct, yes.
That might be something that we could look into. Let me ask you, is there sort of an organization of defense attorneys in this area that you know of, that, you know, maybe they have brochures or they have, you know, contact numbers or things like that, things that we could provide to somebody who's being charged with an offense like this?
Yes, there's an Association of Disciplinary Defense Counsel, and they participate in the regular bench bar committee meetings. And I think this is a topic that came up one or two times in recent meetings that Mr. Stallings participated in.
Yeah, and Mr. Chair, if I could, so to Mark's question, one of the things that we've talked about with the discipline defense bar is having an attorney who is present on certain days when the respondents appear in person. And so that way there's an actual person who's a defense attorney who can give, you know, some quick guidance if appropriate, or set up that time for a 1 hour consultation. So I understand that ADDC does already, their members already do a lot of those free consultations. And so we're just looking at a way of as Professor Robertson put it, remove all these different choices and create more confusion, but really simplify it and have a person there who's dedicated to answering any questions pro-pers might have.
Mr. Chair?
Yes.
If I may, so in thinking about if there are sort of other things we can do in this particular area, I certainly think that the idea of publicizing information about the statistics and the greater likelihood of success is one piece of it. I think what Brandon just mentioned is really a sort of a great idea as well. I think there are nonetheless going to be some attorneys who remain unrepresented. And so one of the other things, and you know, Brandon, you please correct me, I don't know if this has come up in a discussion with the defense counsel, but one of the other things that the bar could think about doing is providing self-help materials the way the superior courts do, right? So they have figured out the line that is drawn between legal information, which they can provide, and legal advice, which they can't. Presumably, we could figure out a similar line and make sure that we're not crossing that line and we're not providing legal advice to the respondent attorneys. But if we do make some self-help materials available, such that for those who still end up unrepresented, despite any increased efforts that we might make to try and ensure that there's counsel available, there is also something that is that's available to help them maneuver their way through the system.
And thank you. And Mr. Chair, if I could just speak to that just real briefly. So State Bar Court has really been a driver of that conversation in regards to self-help materials. And I think it's something that the State Bar Court is very interested in providing more materials on their website. They already do provide some self-help guides, but what I've really been impressed with or impressed upon in sharing our head this year is how different these types of administrative proceedings are in comparison to the other types of practice of law. And attorneys who choose to represent themselves may not be aware of the intricacies of this particular body of law. And so those self-help materials would, I think, help to inform an individual, and maybe even through that further informing, maybe it's impressed on that individual that they really do need representation. So I think that there is a lot of energy to have self-help materials more robustly provided to pro-pers.
Thank you.
Yeah, there's a difference between self-help, obviously, and legal representation. And I think what we're trying to do is help them get legal representation. And the thought just comes to me that this falls in line with legal aid. I mean, it's possible maybe that we could take some of the funds from the IOLTA accounts that go to legal aid, and to help the attorneys who cannot afford to represent, to get representation, something along those lines. It's just a thought where you could get some sort of funding to help those individuals who don't have the resources themselves.
So, Mr. Chair, I think it would be difficult, and we'll be talking in just a moment about funding for legal services. I certainly think it would be difficult in a time of such declining resources as we are in right now with IOLTA funding to apportion a percentage of it to an area of the law that it has not gone to before.
Thank you, Ms. Richquitz. Are there any other comments?
Chair,
Yes.
Sonia.
Delia. Yeah.
Okay. What is the percentage of the lawyers who just are not? Is it not being able to afford an attorney, or is it just because they would rather not have an attorney? Is that the case, or for them to not be represented?
So I'm not sure that we know exactly the answers to those questions. I think that, part of it could just be the fact that, attorneys have a sense that they know the work and should be able to represent themselves. But I also do think that as Professor Robertson remarked, that it can be quite expensive to hire attorneys that specialize in this area.
The data that were used for the statistical model show that about just about 9% on average of attorneys are not represented by counsel. And one would, of course, want to look closely at how that's measured, but about 8.5% of all attorneys are not represented by counsel when they're under investigation by and going through state bar court disciplinary proceedings. And as I mentioned earlier, the figure for African Americans is about 15 to 16% not represented. And these don't separate out the differences by gender. And I believe that for in the actual statistical model, the percentage of African American men who were not represented is even higher than that. So it's about twice as many. The percentage is about twice as high for African Americans than for the group, all attorneys as a whole.
Thank you.
Ellen, if I could, can I ask Dak a question? In regards to the letters that we're talking about being sent to self-represented litigants, is that something that ORIA could potentially take on while we discuss these issues? That way it's not coming from OCTC, it's coming from a division of the bar that I think on its face it shows an agency that is looking at a self inward and is providing that accountability. Is that something that ORIA could take on?
I think so. I think that makes sense. Partly also because we would want to evaluate how effective those messages are. And I would also really want to continue working with Professor Robertson, who actually has some experience working in this area of finding nudges and small incentives and language that might lead to behavioral change. So if it's a behavioral issue rather than an economic issue, yes, I think that somewhere other than OCTC could be appropriate.
Mr. Saleh?
Yeah, so this has been a good discussion. I think there's a lot to talk about here. And I think, as Chris said, we're challenged to come to this with an open mind about how our practices can be changed. Not only in light of what Dr. Farkas found, but just the current discussion in our society. And it seems to me it's too much for us, I think, obviously, to resolve today. And that I think we need to think about how to attack these issues in the short term and in the longer term. So I know that staff in the memo tried to select some issues that could be implemented or studied more rapidly. And then there are other more complicated issues. So today, for example, we've talked about the representation issue, and there do seem to be things that could be done pretty quickly that address that issue, and that's directly targeted to the Farkas report. The other item that could be subject to quick action, at least on an interim basis, is the consideration within OCTC of prior closed complaints. In other words, complaints that never led to discipline. And so, we have to be mindful that looking at those is relevant to the prosecutorial decision, at least in some cases, because they can reveal a pattern. If you have, if you had some cases in the past that are weak and that were closed, but then you keep seeing this, a similar complaint or related complaints over time, that can be important to protecting the public and identifying a problem attorney that needs attention. But at the same time, you could reasonably say there's a period of time where those prior closed complaints, which by definition were just determined not to justify discipline, shouldn't be considered anymore. Maybe that's 3 years, maybe it's 5 years, maybe there's a system that allows access to those older closed complaints only in certain circumstances. That's one of the suggestions to consider in the report in front of us today. I think that's something that, OCTC in working with the RAD chair and vice chair might look at doing soon, and we can consider it also. I don't know that we should make a decision. I don't think we should make a decision on that today because it could have unintended consequences, but it's something that we can look at quickly. But then, so we have these issues that could be dealt with quickly, and then I think we have longer, more complicated issues that we need to consider. And the letter from COAF, I haven't read the whole thing, proposes a task force to look at the discipline system more generally. I think that's something that is worth considering. I think it needs thought and structure to make it something the board could really deliberate about. But Judge Harbin Forte mentions one of 2 cases that have been brought to the attention of board leadership recently. They both involved African-American respondents, and they could be said to reflect a system that maybe is sometimes too rigid and is not enough focused on proportionality and viewing public protection as with a balance of fairness to the respondent and getting the respondent back on the right path versus filing formal disciplinary charges. So without getting into any particular case, and it's not our job as board members to do that, I think we can look at example cases that are brought to us to determine that from a policy standpoint, there might be broader issues to look at. So that is a lot to chew on. There's a lot of bigger issues to look at. And so what I think I would propose to the board is that we ask the RAD leadership, the co-chair, the chair and the vice chair, to work on honing these issues and how we might address them. In other words, is it something that we should continue to be evaluating at the board level, or is it something where we need, a separate group that includes stakeholders and includes perhaps, outsiders, even from the criminal justice system, and people who analyze that to bring their perspective to look at this from a sort of higher level standpoint. I'm not prepared to propose that to you today because I don't know exactly what that would look like, but I think we should work on what that would look like and whether we should proceed with it.
I think that's a good suggestion. And in the absence of such a resolution today, which I agree with you, it may be premature, I think that you as the vice chair, I as the chair, and the 2 the RAD chair and vice chair should address this immediately and not wait for the next board meeting, but be working on defining this in the interim.
I agree.
Are there any other Are there any other comments or questions before we move to a motion? Yes, Mr. Petula.
I agree with Sean that we're not going to fix systemic issues today, and that's going to, I think, be more of a process of constant improvement. But I do think as a board, we need to put some policy together, and I'm not comfortable taking anything off of the table that was laid out today. Obviously, some of them I think need some additional study and review, but there are some I think some easy solutions in those recommendations that we should consider. So I'm not sure exactly what resolution you're moving towards, Mr. Chair, but I do believe that we need to have one that takes action and directs policy today.
Well, let's start with the resolution, the recommendations for the two resolutions that we have up here, and see if we will get a motion and a second to adopt these in order. And then if anyone feels that we should have an additional resolution, we can work on that issue. So let's take a look at the first resolution, that the Board of Trustees directs staff to develop plans to implement reforms 3.1, 3.2, and 3.3 specifically as shown in the resolution.
Mr. Chair, I would make that motion.
All right, moved by Mr. Stallings.
I'll second that, Mr. Chair. Duran.
Seconded by Mr. Duran. Any discussion on this first resolution?
Mr. Chair, Josh
Yes.
Bertula, I would ask for a friendly amendment. I'm struggling with, and I feel like we've studied it quite a bit, why we need to evaluate 1.1 at this point. That issue's come up in front of the board a few times. It seems to me to be a pretty simple solution. And so I'm trying to figure out how we move some of these forward and continue studying ones that need studying.
Okay, I understand your question, but we were looking at just the first resolution, which is 3.1, 3.2, and 3.3, and you referred to 1.1. Are you ahead of us here, or did you mean number one?
Nope. I just want to make sure that I'm being clear. So what you're asking to implement in 3.1, 3.2, 3.3, the next resolution is a evaluation of 1.1 and 2.3. And I believe what you're saying is if we move 3.1, 3.2, 3.3 to implement, that we are not including other recommendations for implementation.
Let's do this. Can we discuss that when we get to the second part of the resolution, the further resolved?
Yes.
Okay. Then I understand you to be withdrawing a suggestion of a friendly amendment, and the motion and second on the first resolution regarding reforms 3.1, 3.2, and 3.3 would stand as presented.
So removed.
Okay, thank you. All right, any further discussion? All right, then, hearing none, Ms. Cohen, please call the roll.
Broughton,
Yes.
Chen, Cisneros,
Aye.
De La Cruz, Dellin,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Pertula,
Yes.
Saleg,
Yes.
Stallings.
Yes.
First motion reflecting the first resolved carries.
Thank you. Now let's go to the second part of this recommended action. Further resolved that the Board of Trustees directs State Bar staff to evaluate, and then I'm cut off a little bit, but reforms 1.1 and 2.3 specifically. Mr. Pertula, do you have a comment on that?
Yes. I believe the reform that we've discussed before, reform 1.1, and that I'm comfortable and in a position where I believe we should move to implementation.
Okay. I personally am not sure that we have done sufficient evaluation to understand the ramifications. And I do agree with Mr. Seleg that some of these may hold hidden problems. But let me ask either Ms. Hershkowitz or Mr. McLeod to comment on the feasibility of changing the resolution to implement as opposed to evaluate.
So I'll take that, Mr. Chair. I think the question that I have is, we don't have data to tell us, or we haven't looked at the data that would tell us what the appropriate level is to raise that de minimis threshold to. At what point do NSF checks become a predictor of subsequent misconduct or related to misappropriation or otherwise? And so, so it may be that the $500 limit that Professor Robertson mentioned is exactly the right amount. I think it's probably unlikely that the current level is the right amount. I think there's certainly room there, but I don't think, I think a quick, what I would assume is a relatively quick look at the data to give us some sense of at what threshold of overage for that account is there a correlation? And then, so maybe what the board might consider doing is to direct that we make the change based on the, like that we are directed to run the data to determine where that threshold level is and then raise the threshold to that point where there is a relationship between the substantive predictors of future misconduct.
Okay, thank you. Yes, Mr. Select.
Yeah, so my take on this, first I want to clarify that, and Melanie and Steve may want to chime in here. My understanding is we're talking about, and I'm looking at potential reform 1.1 now, we're talking about at what point OCTC simply looks into what's happening with the trust account to determine if the overdraft presents a public protection problem. So this is not like a threshold for automatic discipline, for example, or even the filing of disciplinary charges. So we should keep that in mind. I think that the study that is discussed or the evaluation is something that could be done by our next board meeting. And what I think the board would want to know before we implement the new threshold is to be sure there's some reason to know that, for example, someone who has gotten a series of overdrafts that are for small dollar amounts, that rarely leads to discovery of a serious client protection problem, that there's actually a larger misappropriation of funds going on or not. So, so I think the reform is on the right track and it's something we should consider. And OCTC in its discretion can implement this even more quickly than the board can. And I think we should encourage them to look at this quickly and look at the data and make a reform internally, bring it back to the board, and the board can evaluate whether the reform is sufficient based on what OCTC has found. So that would be my personal point of view about that particular issue.
Right. So you would be in favor of adopting these two recommendations as stated. Is that correct?
Yes, and I'm not sure we might want to add it as a resolution that the board asks OCTC to, if it determines that a reform is in order, to implement it immediately and to report back to the board rather than necessarily waiting until the September meeting. So, because I think Josh is absolutely right that we want to look at these issues with expedition.
Right. I do believe that given the current circumstances and the long history of some groups and races, that there's an understandable level of frustration that would act or suggest action instead of study. But I do think at the same time that it's important to feel comfortable that we are not creating unintended consequences and that we have at least given this as much a good evaluation as we can. So Mr. Selig, if you would, you want to scratch out a proposed third resolution while we continue the discussion in case we might want to throw it up.
Sure, I'll do that. I'll send something to the secretary right now.
Thank you. All right. Now, is there any further discussion on this further resolution that we have presented to us on our screens?
I hesitate to throw this out, but I'm a little confused. I understand that we're trying to impose some positive corrections to our discipline system, but the question that I came at to begin with was, what I don't know that's being answered here is, why are African American men being disciplined at these 3 times greater levels than non-African American men? And why is what we're doing here, how does that sort of answer that question or deal with that issue?
Well, do you want me to just from
go ahead and give your, I'm forming my thoughts in response, but go ahead, Mr.
So just from the data side, the RA bank matters came up because that is a specific complaint type, or if you want to call it a complaint, it's a specific type of case where African American men were overrepresented. So that just became a node of looking into, like, well, what does the pipeline look like, if you could call it that, the pipeline into the state bar discipline system. So the exact sequence of events that would lead from an RA bank matter to actual discipline is a little murky. I think that that's true, but there is an overrepresentation of this type of complaint against African American attorneys that we noticed, in particular on the high end among attorneys who have a high number of complaints. That's where this recommendation really originated. The second of these, the evaluation of complaints closed without discipline, gets to the question of whether there can be a preventative approach rather than a disciplinary approach. The number of complaints against attorneys was actually a strong predictor of subsequent discipline, and those numbers are skewed very heavily against African American men. And so looking at that in particular and seeing if that might be a way that the state bar could act in a constructive, preventative manner rather than in a punitive manner seems to be the direction that this particular recommendation is going. I would also invite Professor Robertson, if you have further thoughts. I mean, a lot of this staff report, most of the staff report is cribbed from Professor Robertson's report. He's done a tremendous amount of work and has been very thoughtful about this. So I would actually invite him if he would like to speak to this issue as well.
I mean, I remain ready to do so, but I think I'll pause in case there's any more specific questions or where you'd like to direct me, because I've had so much of the floor already, but happy to answer any questions.
Mr. Chair,
I mean, I realize it's a long discussion, and the drift is what I'm getting is that these specific things are related to his studies and the other studies that would answer that question that I raised.
Let me ask Mr. Duran to go first, and then Professor Robertson, if you have anything in response to Mr. Broughton's comments.
Thank you, Mr. Chair. This is my attempt to give Professor Robertson a specific question. So the second part of this resolution about evaluating complaints closed without discipline. Is it the case that the data set, for lack of a better word, that we have from Dr. Farkas's analysis gives us something to evaluate? Or are you talking about having to go out and conduct a bunch of interviews either with OCTC or disciplined attorneys? Where are we going to get the data and the information looked for in number 2?
So this really connects, as I understand number 2, this is the staff's recommendation.
that this idea of proactive regulation really grows out of that governance and a public interest task force. So the nice thing is you're not starting at zero. They spent a whole spring, and as I understand that task force, this whole spring looking at the issues of what that would do. Other jurisdictions in New Zealand are already using these methodologies. And so the short answer is the data already exists within the state bar to look at the lifespan of an attorney and the sorts of complaints that predict them in the future having discipline. That's essentially what Dr. Farkas did. The idea would be, one way to put it is to take, what he did is looking backwards retrospectively. You take those same models and variations of the models to instead look forward and see, oh, this attorney is on the track that may lead to disbarment in the future. Let's figure out how to intervene. So as I understand the project, much of that data is already within the state bar, but of course it's always effort to get it in the right structure and in the right equations.
Thank you.
Any other questions or comments? Hearing none, the chair will entertain a motion to adopt or pass the second further resolved as presented in front of you, parts 1 and 2.
So move.
I'm sorry, and I have a small screen, so I'm
It's
not
Sonia
sure.
Dellen.
Sonia Dellen moved. Do we have a second?
Second.
Oh,
That's Brandon.
Stallings. Thank you. Any further discussion? All right, Ms. Cohn, please call the roll.
Broughton.
Alan, sorry.
Yes.
So I've sent language to staff to add to the resolution, and so I would propose it as a friendly amendment to Sonia. They're going to put it on the screen now. There's 2 items. I just sent a second one.
So Sean, I picked up this one. And you're suggesting adding this to this existing further resolved, or voting first on the further resolved and then adding yet another further resolved?
The new language should be paragraph 2. So move it up to be 2.
To replace the existing language?
No, in between existing 1 and 2.
Okay.
Yep. So the additional item would read as follows: OCTC should evaluate the results found in item 1 as soon as possible, adopt an interim reform as the results might support, and bring the results of the investigation and interim reform to the board for further consideration at its next meeting.
But now, is that the only change you have, Mr. Slegg?
I have a new item 4, or if staff can't, we could do that as a separate resolution. So I'll ask staff what works best for them, because they're managing the screen.
Well, while we're doing that, Mr. Chair, let me just, if I may, just raise the question of whether the issues that Josh and Sean brought up with respect to delegating some authority to Brandon and myself, and I think the chair and the vice chair of the board, to work with staff in the interim to get these things moving, whether that should be memorialized in the resolution just for clarity's sake.
Yes, that's probably a good idea. It's required. Probably a good idea.
Donna, not that I don't trust staff or anything. I absolutely do.
This is Debbie. I agree with that. I agree that there should be some oversight from at a board level in terms of there are going to be some changes made, that there's somebody at a board level who's also looking at it. I think there are other people looking in would think that is a more fair process in terms of what's being done. I think I like that oversight.
Okay.
And Mr. Chair, if I may, so we have bi-weekly meetings, Ruben and I do, with OCTC, and we're apprised of many different topics, and this, I think, will definitely be at the top of our list, or continue to be at the top of our list. Certainly something that is stated on the agenda.
All Let's go back then to the motion that's on the table. We have two friendly amendments that have been suggested by Mr. Saleg. Number 2, is that now in your final form, Mr. Saleg, as presented?
I think so. And then
All right.
4, I have a couple quick changes before we read it to the board.
Okay, go ahead.
Just because a couple typos that originated from me. So DAG in the second line after 5 years, add 5 year, add the word old, OLD. And then fourth line, there was a blank I had. It says attorney at the level of, it should be blank. So Melanie and Steve, what I'm looking for there is the title of the person who's just above a supervising attorney.
Just above a supervising attorney would be a assistant chief trial counsel.
That's it. Thank you. And does that language, does that make sense within your hierarchy, what's been written there?
Yes.
Okay, thank you.
And I apologize for not understanding that showing is works there.
Okay.
Okay, that's no problem. So I'll read it now. So proposed additional paragraph 4 would be OCTC should implement an interim reform that prior closed complaints more than 5 years old should not ordinarily be considered in evaluating and investigating a new complaint, with exceptions permitted based on a written showing to an attorney at the level of assistant chief trial counsel or higher within OCTC.
I get the only
this
thing.
Is a variation of one of the recommendations in the report.
Florence?
Yeah, if I could just raise one issue related to this. And Professor Robertson talks about it in his recommendations. When we talk about complaints not ending in discipline, there are other ways that complaints resolve. So for example, a warning letter, we issue warning letters, we issue directional letters and resource letters. And so while they're not considered discipline, we are putting someone on notice that they have engaged in some concerning conduct. And I think we would be concerned about not having the opportunity to evaluate those kind of complaints, especially if we're seeing repetitive behavior. And as I mentioned, Professor Robertson does note that in his recommendations and suggests that that might be an exception. And so I would ask that you consider that.
Is that what he's saying though?
So Melanie, from my standpoint, that point is well taken. Could you suggest some language, and then also just a bigger picture? This is an interim measure. I think if the board chooses to adopt it, and it's something that can be looked at more deeply, and the OCTC can certainly bring back proposals for honing it in the future. I want that to be clear. But anyway, if you have some language to address the issue you've raised, because I think it's a valid one, that would be helpful.
Okay, I'll try to send something.
And Mr. Chair, I do have a question for Melanie on this. Has there been any sort of analysis on the impact on staffing and any sort of impact on OCTC's ability to do your work in the review department, or the intake department rather, and how much this would impact that workflow and then lead to things such as backlog and delay in cases being litigated?
Well, I don't necessarily think that it will lead to delay in cases being litigated. I think that the issue comes up logistically for us where there are other reasons why we are looking at prior complaint histories. So for example, we often get correspondence from folks, and I think actually Professor Robertson may have mentioned this, where on its face, if we were not to have the ability to look back, we would think that these were new complaints, when in fact these individuals are complaining about the same respondent attorney and the same conduct. And so that's part of the analysis when we're actually reviewing complaints initially. So I will just say, just in the last 2 weeks, my intake staff says that they had to look back on 7 old cases, the oldest being from 1999. And had they not had the ability to do that, we would have ended up opening new cases when in fact these had already been complaints that had been considered and closed. That being said, I think that we can fashion a way to do it where we're not having the, the intake attorney who's evaluating the complaint itself actually do that initial evaluation of whether or not this is in fact a new complaint. So it presents some logistical challenges, but I don't think that we can't get over them.
Okay, have you sent in your wording?
Oh, sorry. No, hold on.
I'm too busy
Send it to
answering
you. Sean, I can send it to you.
Okay.
Alan, I think Professor Robertson wanted to make a comment.
Oh, okay. I don't have everybody on the screen, so please, Professor Robertson.
Yes, I just mentioned that, you know, the reasons I framed my 2 recommendations as expunge and archive is because I believe some of my interviews suggest that, you know, if you imagine the human factors of how the attorneys are actually using their case management system, it suggested to me that it might actually be hard to avoid actually seeing the list of prior complaints just in your regular workflow. So as an interim measure, I think this is good guidance, but as a medium or longer term, you might actually have to look at ways to actually archive or expunge them.
Okay, thank you.
Sean, I sent it to you. Take a look at it.
There we go. I got it. Okay, that looks good. Let me just make a little tweak and I'll send it right now.
And Mr. Chair, while we're working with the language, I think one thing to raise again with the board, and Professor Robertson mentioned this in his report, is that a regulatory agency had an audit conducted, and that was one of the, I think, major findings of that audit, that the prior closed complaints were not considered by that agency. And so I just want to make sure that that any changes that we make, you know, and this goes back to, I think a point that Sean made, is that do we want change? Yes. Do we want to make sure that we have the right change? I think the answer should also be yes. And sometimes that requires a little bit more of a nuanced study and approach. And so I guess I wouldn't want to end up with an interim rule today that could have negative impacts on our ability to protect the public, especially when we have a regulatory agency being criticized for doing the very thing that we could impose in the interim. So I think that's just a concern that I have. And I don't know, Sean, what your thoughts are on that.
And I have to apologize. I was typing on Melanie's insert and I didn't process what you just said.
I think just the issue of having an interim rule that would impose reform that another regulatory agency had, you know, had as a policy, but then was a very, I guess, resulted in a negative review by an auditor.
I see. Okay.
Well, the point being that, yes, we want to address this. We have been doing this. I think we've been very self-critical and didn't accept the first report at face value, but as an institution, we said, let's drill down and see if any of this reflects, you know, implicit bias or disparate impact or whatever. And we're in the process of working through this, but we do have an obligation to the public to keep public protection, you know, in our mind at all times. So we're trying to achieve a balance. It's not easy, and it will be, as Josh Petula said, an ongoing process. The point is not necessarily to make the changes as quickly as possible, but to make the best changes and to keep making them as long as they need to be made.
And if I may add, Brandon, I do believe that the finding that you were referencing dealt with a situation where they didn't look at any prior complaint, or they didn't look at any prior complaints at all, as opposed to what's being proposed here, where on an interim basis anyway, at least looking at prior complaints that are less than 5 years old. And so you can make I think a solid argument that we are sort of that we're not just sort of following the practices that were deemed previously to be bad practices, but looking at a way to minimize the impact of the fact that we know that African American male attorneys are getting a disproportionate number of a disproportionately greater number of complaints, and so this is a way to minimize it, but without going so far as to say we never look at any prior complaints at all. Period.
Yeah, that makes sense.
Okay. Yeah, Mr. Saleh.
So I sent the language. I would say in response to Brandon's comment, it's well taken. I think I'm interested, Melanie and Steve have a different view. I think you could, after more careful study, you could make the case that you could even shorten this period, say to 3 years. But complaints that are 5 years that didn't result in actual discipline, that's pretty old, and that's a pretty long time with no further complaints. So it doesn't seem like an unreasonable balance to me. So I'll throw that to Melanie and Steve, but before I do that, let me just go to the new sentence. There, thank you. I think we need to add one more thing. Melanie, I added agreement in lieu of discipline. Do we also need to add private reproval? Because a private reproval isn't discipline technically.
It is
right?
It is discipline.
It is discipline. Okay,
Yes.
Then we don't need to add that. All right, so Melanie, does that definitional sentence seem correct to you? And then
Yes.
you could address the larger issue.
Yes, it does. Thank you.
Okay.
Well, in terms of the number of years, I think the challenge in thinking about what is a pattern is, really the only thing we have to look to is case law. And it could be, it could be a volume of complaints within a couple of years, or it could be repetitive behavior over a lengthy period of time. But what that lengthy period of time is undefined. So I'm a little bit concerned about the idea of 3 years. I mean, I think it's something to look more at, as you mentioned, Sean. I think 5 years is a better balance.
Okay, thank you. All right, so I will offer these changes as a friendly amendment to Sonia and her second.
Okay, Sonia, have you had a chance to review the language that Sean has suggested?
Yes, I've been following, yes, and I still moved. Yeah.
Okay, fine. And so you accept those friendly amendments?
Yes, I do.
Thank you. Mr. Stallings, do you?
Yes.
Is there any further discussion about the recommended resolution as presented with the friendly amendments?
Mr. Chair, I think we still need the language about board oversight. Says further resolve, the board of trustees direct state bar staff to evaluate. I think that would be the appropriate place to insert a phrase, something along the lines of direct state bar staff to evaluate reforms and work with RAD leadership on 1.1 and 2.3.
Could you point Mr. McLeod to where you would suggest that insert be and give him the language you would like?
I think he just right there after reforms and work with RAD and board leadership on recommendations 1.1, well, and there you go. Thank you.
Okay. Sonia, that's another friendly amendment? Do you accept that?
I agree. Yeah.
Thank you. Mr. Stallings? You got to go on mute, man.
Yes, I agree.
Okay, thanks. Any other discussion? All right. Ms. Cohen, please call the roll.
Broughton,
Yes.
Chen, Cisneros,
Yes.
Dela Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Pertula,
Yes.
Selig,
Yes.
Stallings.
Yes.
The motion carries with Sean's 2 friendly amendments and Ruben's friendly amendment as well.
Thank you. Well, thank you to the entire board for your very thoughtful consideration of this agenda item. I want to again thank Professor Robertson for presenting his paper, for doing the work, and for helping guide us to this first station on a long road. And we will continue with this, and I believe that there will be agenda items to further this work on the next board meeting's agenda in September. So now we will take a break. It is 1:40. Can we take a 20-minute break and resume at 2? Is that enough time for everyone? Unless anyone waves their hand, I will assume that it is. All right, a 20-minute break, return at 2, please. Oh, fuck.
May I encourage everyone to mute their microphones, just out of an abundance of caution, and you might want to also just turn off your.
As soon as we start recording, we can get back with it and get started.
Mr. Chair, we are now recording.
Thank you. Welcome back, everyone. We're resuming the meeting of the Board of Trustees, and we are turning attention to item 702. And I understand that in place of Ms. Hershkowitz, Randy DeFatorum will present this matter. Good afternoon, Randy. Welcome again.
Good afternoon, Mr. Chair, members of the board. Randy DeFatorum, Director of the Office of Professional Competence. Item 702 presents a staff recommendation for a charter and composition for the working group on closing the justice gap. This matter continues the board's consideration of the recommendations of the Task Force on Access Through Innovation of Legal Services, ADLS. To briefly recap, at the March meeting, the board took action on 3 ADLS recommendations. The board referred ADLS work on a non-lawyer paraprofessional program to the then new State Bar Paraprofessional Working Group. The board also issued for public comment 2 proposed amended rules of professional conduct. The 2 proposed amended rules actually have now returned to the board following consideration of the public comment by COPRAC. One of the proposed rules, Rule 1.1, concerning lawyer competence, was just adopted by the board this morning. It was consent item 54-123, and this rule amendment will be submitted to the Supreme Court for consideration of approval. The other proposed amended rule, Rule 5.4, concerning an expanded exception for fee sharing with nonprofit organizations, was considered by RAD on Tuesday and issued for additional public comment. The remaining ADLS recommendations were considered at the board's May meeting, and the formation of a working group on closing the justice gap was authorized to address all of the remaining ADLS recommendations. As summarized on page 2 of the agenda item, these recommendations are an exploration of a regulatory sandbox for gathering data on innovative systems for delivering legal services by considering changes to existing rules, including the rules governing unauthorized practice of law and fee sharing with non-lawyers. A recommendation for a new rule of professional conduct, 5.7, similar to the American Bar Association's Model Rule 5.7, concerning lawyer provision of non-legal services. A recommendation for revisions to the rules governing lawyer advertising and solicitation, taking into account the most recent changes made at the American Bar Association level with the Model Rules of Professional Conduct and a study done by the Association of Professional Responsibility Lawyers. Fourth, there was a recommendation to review the regulations governing certified lawyer referral services to ensure that they properly balance public protection and innovation. All of these recommendations are included in staff's proposed charter for the working group, which is provided as attachment A. In that charter, the regulatory sandbox is enumerated section 1 of the charter, and it has 7 subparts, A through G, that detail particular matters for further study. The lawyer advertising matter is section 2 of the charter. Lawyer referral service regulations is section 3. And some further proposed rule of professional conduct revisions are included as sections 4 and 5. In addition to the working group charter, staff has described an appointment process and outlined general categories for the composition of the new working group. Regarding the composition of the new working group, the categories listed include legal ethics experts, legal services organization representatives, and technology experts. With these various categories, it is anticipated that there would be 15 to 17 appointments ultimately to the working group, including a chair and a vice chair, of course, all depending on the applicant pool. And as was the case with ADLs, a liaison from the Supreme Court would be sought. The agenda item indicates a range of 15 to 17, really for 2 reasons, rather than sort of a set number. The composition list first should not be construed as a list of discrete appointments. It's quite possible that a single applicant in the applicant pool could fill more than one category. For example, a trial judge might also be a person who served on ADLs and thereby fill 2 of the categories. The second reason for the range is that depending on the applicant pool, in order to have enough members to handle the workload set forth in the charter, there might be more than one person recommended for a single category. For example, the appointment slate ultimately might include more than one legal ethics expert, which was the case with the ADLs task force itself. With this general list of categories to guide the outreach, staff would implement an application process that would be conducted to allow the board to consider appointments to the working group at the board's September 24th and 25th meeting. Staff's recommended resolution is on page 7 of the item, and I'm happy to answer any questions about this item. Thank you.
Thank you, Randy. Are there any questions for Mr. DiFittone? Yes, Debbie.
I have a question, and some of the comments he had earlier, people were asking if we could have more consumers, people representing the consumers on the task force. On ADLs, was there more than one consumer person? I mean, that was a consumer and not necessarily a consumer attorney.
We weren't really able to have on the ADLs task force representation of actual consumers of legal services, but that is one of the categories listed for the closing the Justice Gap group. In fact, we've had preliminary discussions about how there might be social media strategies for actually securing that voice, the actual voice of a public consumer of legal services, and that it might not just be perhaps one consumer, it might be an individual consumer of, say, family law or estate planning. It might also be a representative of a consumer in terms of a small business. Again, it all sort of turns on our efforts for outreach and the ultimate applicant pool. I will say from experience that for many, many years, the COPRAC committee has had a policy of having more than one non-lawyer public member on that group. But just because of the realities of trying to interest the public to serve in these types of groups, it's been difficult. But we are targeting, as part of the composition, true consumers of legal services.
Okay, I like that you said you're doing some sort of social media outreach, and I think that you might be a little bit more successful with that, especially if you might outreach to some activist groups that that deal with, you know, advocating for elders, for seniors, or for single moms or whatever. So, okay, that's all I want to know. Make sure we got more than one consumer if we can, and not necessarily an attorney.
We're definitely striving for that.
One of the other things that I would suggest as we're doing the social media campaign, I think one of the things that we're looking for is, you know, if you've got 2 or even 3 consumers on this working group, they may have a very narrow, specific focus. And so one of the things that might frankly be really beneficial as we're moving through the process is if we're able to line up enough consumers with interest that we can do a consumer focus group. We can bring some of the issues to, you know, focus group consumers and get their feedback and get their response. That might frankly be a better way of getting the consumer input than finding 1 or 2 individual consumers who can broadly represent the ideas and thoughts of consumers out there.
Thank you.
Any other questions for Mr. DeVentura? Okay. All right, any discussion? All right, let's turn to the resolutions that have been recommended on your screen now. And if there is no further discussion or comment, the chair would entertain a motion to adopt both resolutions as stated.
This is Jose. I'll move adoption.
Moved by Mr. Cisneros.
I'm sorry, Mr. Chair.
Yes.
I see that Sean Saleg is currently listed as a panelist, and he's got his hand up in that context. I've asked him to be, as he's on the attendee side, I've asked him to be promoted back to panelist, and I just want to make sure that we don't foreclose an actual question that he might have.
Okay, fine. I thought he just cut out on us.
There we go. I wouldn't do that. I think I'm back on.
All right.
I had to switch devices, so sorry about that.
Sure.
Yeah, I just wanted to chime in. I think we need to. I think as Donna indicated and Debbie, this is a good starting place. We need to maybe give a little more thought to the composition, and I really like the idea. I had kind of a similar idea of having a group of consumers, and then that may be different than the group that's actually members of this commission, because it seems that for, you know, real retail consumers, more of a panel or a focus group type approach might give us more information, and as opposed to who's chosen to actually be a representative on the group. So I think that's worth some more thought before it comes back for final approval by the board.
Is that a change you want to make to either of the resolutions, or just a direction?
I think it's just kind of an understanding. I looked at the resolution. I don't think it needs to be changed to accommodate that.
Okay.
But you know, just piggybacking on that, we might want to reach out to something like, you know, Cal Endowment or those kinds of groups that work with multiple communities, as to have them to have the representative, and then they could also do the focus groups, because that's kind of what they do as well. So something along those lines.
Right. Okay.
This is Randy. Let me mention that on page 5 of the agenda item, with respect to the composition, it does indicate that we're contemplating that the chair of the new working group would be authorized to designate subcommittees and also appoint additional advisory members as needed to strategically add expertise on discrete issues. And so, for example, there could be an advisory group of consumers, which would be a much more wider spectrum. And in addition to perhaps the actual voting member or members who would be representative of the consumer voice.
Okay. That's good.
Okay. We have a motion. We need a second.
Second, Debbie.
Okay. Moved by Mr. Cisneros, second by Ms. Manning. Is there any further discussion? Ms. Cohen, please call the roll.
Rajan,
Yes.
Chen,
Yes.
Cisneros,
Aye.
Dela Cruz, Dellen,
Yes.
Duran,
Yes.
Iglesias,
Yes.
LeBron,
I'm recusing.
Manning,
Yes.
Pertula,
Yes.
Teleg,
Yes.
Stallings.
Yes.
Motion carries.
Thank you. Item 703, approval of proposed interest on lawyer's trust account IOLTA grant distribution for 2021 and review of plan distribution for 2020. The chair of the Legal Services Trust Fund Commission is scheduled to speak. Do you see her lurking around in the office? And if so, would you please let her in?
Good afternoon, Mr. Chair. This is Juan Nguyen. I'll be presenting the agenda item with Monisha Globby.
Okay,
On the
that's
line,
fine.
but she needs to be promoted to as a panelist. Sarah, can you help her out?
Yes, of course. Thank you.
Yeah, you are cutting in and out just a little bit, so please stay as close to the microphone as you can. Thank you.
Great.
So, Ms. Nguyen, would you like to proceed?
Monisha, were you able to be promoted?
I don't see her.
We're working on it.
Okay. So I can start. Would it be okay if I share my screen? We have a small PowerPoint presentation.
Sure, yes. Okay.
Do you see the PowerPoint?
Yes, we do.
Great. So again, my name is Juan Nguyen, and I am the acting program manager for the Office of Access and Inclusion. And Monisha Gloggy, who will be presenting this agenda item with me, is the chair of the Legal Services Trust Fund Commission. So with this board agenda item, the Board of Trustees usually sets the distribution amount for IOLTA grants. And this board agenda item is to approve the 2021 IOLTA distribution. The board does not usually review mid-year distributions. However, on March 16th of this year, the Federal Reserve dropped the federal funds rate to near zero, and we had to revise our IOLTA revenue projections for the year from $39 million down to $20 million. Due to the dramatic drop in IOLTA revenue, in addition to approving the 2021 IOLTA distribution, we would like to ask the board to review and maintain the 2020 IOLTA distribution, which is currently set at $55.3 million. This is a roadmap of Monisha and I's presentation today. We're going to go over the IOLTA statute. We're going to provide some background on the funding sources that comprise IOLTA grants. We'll talk about the reserve policy. We'll talk about how the commission came to its projections for 2020 as well as 2021, and we'll conclude with the Legal Services Trust Fund Commission's recommendations.
Great, thank you.
So the Office of Access and Inclusion, in conjunction with the Legal Services Trust Fund Commission, we're responsible with administering several legal aid grants to qualifying nonprofit organizations throughout California. IOLTA stands for Interest on Lawyer Trust Accounts, and we're governed by the Business and Profession Code. The IOLTA statute was adopted in 1982 and has been implemented. It was implemented in 1984 after a series of legal challenges. The IOLTA statute specifically requires lawyers to place nominal client funds or funds are deposited for short periods of time into interest-bearing accounts. The interest is then paid to the state bar, and we distribute them as IOLTA grants to our qualifying legal aid programs in California. Just a quick note, if you're not aware, the IOLTA statute regulates attorneys and not banks. We work with banks to ensure that they are in compliance. However, we do not have statutory authority to regulate banks. If a bank is not in compliance, they are removed from the list of eligible financial institutions, and then we work with attorneys and law firms to remove their deposits from those banks. We have an entire bank compliance team in our office that work to collect the bank remittances and to verify that banks are remitting the correct interest rates. The statute the last time the statute was amended was in 2008. And this, the amendment now requires banks to treat IOLTA accounts fairly. This is called the comparability rule, and it requires banks to offer comparable interest rates and products for similar accounts. So if a bank does not want to provide a similar product, they can provide what's called the established compliance rate. The ECR rate was set forth by the Legal Services Trust Fund Commission, and it is 68% of the federal funds rate or 0.68%, whichever is higher. Since the federal funds rate is currently at 0.25%, we are lucky if banks choose to remain at the 0.68% rate. And another thing that we'd like to note for the Board of Trustees is that there's not a proportional correlation between the federal funds rate and the IOLTA revenue, even though the federal funds rate does impact IOLTA revenue. And this is because as interest rates go up, banks don't automatically adjust their interest rates up. It takes a lot of work on our end, and specifically in our department, in order for us to get banks to go up to the appropriate level. And the inverse of that is also true. When interest rates plummet, banks don't automatically go down to that lower rate. And some of them do elect to stay higher. And as you are all aware, there was a leadership bank program that was created last year where banks can actually elect to pay at least the ECR rate in all of their IOLTA accounts. And we're hoping with the leadership bank program, this might buffer some of the dramatic reduction on IOLTA revenue. So we also wanted you to be clear that even though we call these grants IOLTA grants, the grants are supported by a variety of revenue sources, including voluntary donations to the Justice Gap funds, which includes also Cypre donations. The total has usually been around $1 million annually, but because they include voluntary donations in Cypre, the amount is hard to predict. IOLTA grants also include the $40 opt-out voluntary contribution in their attorney licensing fee. And that's been about $6 million annually, though we predict next year it will go down to about $4.9 million. IOLTA grants also include tax intercept funds, as well as grant repayments from unspent or returned IOLTA grants, as well as investment income from the IOLTA revenue themselves. The bulk of the IOLTA grants are still from the interest, the IOLTA interest. However, just recognize that there are a number of sources of revenue that go to contribute to making up an IOLTA grant. This is a graph that shows the IOLTA revenue distribution, the Fed funds target rate, as well as the total average balance from our top 20 banks from 1990 until now. And I just wanted to point out a couple things. The solid blue line is the IOLTA revenue in millions of dollars. It was about 20.7 million in 1990. And we reached a peak in 2019 last year with 47 million. We're now, with our latest projection for 2020, we'll be back down to $20 million. The short red dashed line represents IOLTA distribution in millions of dollars. So if you compare the short red line to the blue line, It kind of tracks the dips, but they're not identical. And you'll notice that the IELTO distribution for this year that's currently set is at $55 million, which is the largest distribution that we've ever had. The medium line represents, the medium green dash line represents the federal funds target rate. In 1990, it was as high as 8%. We're back down now to 0.25%. And if you'll notice that around the Great Depression, the last recession, I'm sorry, it hovered again at 0.25%, and it stayed there for a number of years, for 5 to 6 years at least. So our economic forecast is that with this recession that we're entering now, is that the federal funds rate will remain low for some time. We don't have a prediction of when it will go back up, but we do anticipate of the Fed funds rate being low for at least another 2 or 3 years. I also wanted to quickly go over the reserve policy for you, and a little bit of background on the reserve policy. The latest reserve policy is attached in the meeting materials. So from 1984 to 1992, the reserve policy was to distribute the total money projected to be on hand at the end of the prior year. So in other words, we collected money for an entire year and gave out the total amount of that money the following year. So we always had 100% cash on hand for distribution in the next year. From 1992 to 2006, as a result of low and fluctuating interest rates, similar to what we're now in, the trust fund program revised the reserve policy, and the Board of Governors at the time approved to have a range for the cash on hand from a 30% to 75%. And then the latest revision to the reserve policy was in 2006, where the reserve policy outlines a 4-step calculation in times where the revenue is increasing. So last year, when the board went to approve the distribution amount and the reserve, because interest rates are rising and income was rising, we went towards this. We utilized this 4-step calculation. However, now that we're in a declining income environment, the calculation no longer applies. The reserve policy doesn't give a lot of guidance in terms of what to do in a declining income environment. It just says that the target reserve rate should be 30 to 75%. That 2006 memo also says that at some point, the Board of Trustees and the Trust Fund Commission should look to develop the reserve policy more to give more guidance in a declining income environment. So the Trust Fund Commission would like to take this up as they are engaging in their rules codification process. So at some point in the next year or two, we will be bringing forth for your approval a revised version of the reserve policy. And this is just a chart that lays out what the federal funds rate has been on the IELTO revenue and the IELTO distribution for the last 7 years. So just to note, this time last year, when you went to approve the IELTO distribution for 2020, the Fed funds rate was at $2.5 million. The IELTO revenues that we generated last year was $46 million. At that time, we had projected for 2020, we'd be at $39 million. However, with the Fed funds rate dropping in March, we've now revised that projection down to $20 million. We do anticipate, again, that the Fed funds rate is going to stay at the 25 basis point for a few years. And so now the question is, how long will it take the banks to drop to the low kind of interest rate? We think that it's just a matter of time, and that we project that in 2021, our IELTO revenue will be 8.2. We also wanted to give you a kind of a little glimpse into the Legal Services Trust Fund Commission's thinking. A lot of the numbers are based on projections, and the staff and the commission worked together to kind of figure out what was the most reasonable projection. We ran projections for the commission to consider an aggressive projection, a moderate projection, and a conservative projection. And we just want to let you know that what's important to understand is that our top 10 banks make up 80% of IOLTA revenue. And because they make up such a large portion of IOLTA revenue, we really concentrate our efforts on those top 10 banks. And we really try to see, forecast what they're going to be doing in the next few months, as well as into the future. And we concentrate our efforts on those 10 banks. With the aggressive projection, which the commission did not choose to adopt, we had projected that Wells Fargo, which holds our largest deposit, they hold about 25% of our total deposits, that they would remain a leadership bank through 2022. We think that this is very unlikely, and so the commission actually did not go with this scenario. They went with the more moderate scenario, which is the slower decline in interest rates. That at some point the banks would dip down to the 0.16 interest rate, but that the decline would be slower and it would happen throughout 2020. The more conservative projection that the commission did not adopt was that that banks would drop pretty much instantaneously to that 16 basis point, and that's actually been playing out. We're tracking this pretty much daily and weekly, and so far the banks, there have been some banks that have dropped, but they haven't all dropped to the 16 basis point. So that's good news, and it's seeming like the moderate projection is playing out as we anticipated. So with that, I'm going to turn it over to Banashe.
Right.
Banashe, are you on? Were you able
I
to
am
get on?
here, yes.
Great.
Thank you so much, Duan. And thank you to the esteemed body to allow us to come before you and share out the information. So as you're aware, the federal funds rate was reduced to 0.25% on March 16th, 2020, and it remains there today. To provide this esteemed body with some context, upon receiving the news of the dramatic drop in the FFR, the executive staff, the executive committee of the commission immediately began to diligently work to secure further facts through a more measured lens, as Duan just outlined. Over the next several months, the commission and the board liaisons, Debbie Manning and Chris Iglesias, which I'd like to just take a moment and acknowledge them for their insight, their partnership, and their collaboration during our discussions. They've been indeed a pleasure to work with. We held 4 meetings, 2 of which were additions to our existing meeting schedule. We held additional several conversations with the executive committee and executive staff. We heard from programs, the community, the Legal Aid Association of California, and Judicial Council. And all of the discussions were in depth and robust. They were not taken lightly. And we approached our decision in that manner as a commission. After the review of the April bank remittance, which was the first full month since the FFR changed, staff projected the 2020 IOLTA revenue at approximately $20 million for that calendar year. Though this amount is nearly $19 million less than the projection of the 2020, this time last year, pre-COVID-19, there are sufficient available assets for the State Bar to make timely and complete grant payments through the end of 2020, while there's still a reasonable reserve. Changes to the 2020 distribution are discretionary. And under normal circumstances, the mid-year modifications and decrease to IOLTA distributions have not been contemplated in the past by either the board or the commission. Even during, if some of you recall, the last economic downturn in 2007, 2008. We can move to the next slide, please. Thank you. So here, it's really important to stress that these are projections. We're assuming that interest rates remain near zero through the remainder of 2020 into 2021. We also are assuming that we have a $5 billion in IOLTA assets There's been an average increase of 10% in assets that last few years, in the last few years. And we think even if there's a drop, we can still count on about 5 million in assets. We usually get about $6 million in attorney donations through the annual licensing billing. Since there's been a rise in unemployment, as everyone's aware, we're projecting a drop to 4.8 million in donations. A modest drop in the tax intercept funds. And if we could go to the next slide, please. Thank you. So given the dramatic decline in the interest rates and the ensuing economic crisis, the Commission found that it would be prudent to consider alternative funding scenarios for 2020 IOLTA funding, including the following, which would be no change, a 13% reduction, a 25% reduction, and a 33% reduction. Any reduction in 2020 would go to the following year distribution for reserve, allowing for a more gradual decline over the next few years. So therefore, what we did is we dispersed a survey to 99 grantees that we have, and 93 of them responded. We were able to secure their feedback on their preferences regarding the 2020-2021 IOLTA distributions, as well as any impact they anticipated operationally to their capacity resulting from COVID-19. Several comments mentioned the increased demand for services given the ongoing crisis and the fact that reducing funding now may impact their ability to provide services. Similarly, some have assumed financial obligations that they expected to meet based on the previously approved funding distribution and would risk default or layoffs with major decrease in funding. So while maintaining the current 2020 distribution of 55.3 million will result in a 57% decrease in 2021 grants, to 23.6 million, staff and the Commission strongly believe that the no change recommendation, coupled with allowing for a considerably greater flexibility with carryover funds for 2020 and 2021, which we already approved in a past meeting, will enable the programs to address their individual needs more effectively. And at these times, the grantees have shared with us what they're facing, and we definitely hear them. I'm going to turn this back over to ADJOURN for slide number 11, and then I will rejoin you again for slide number 12 and the end of our presentation.
So in your meeting materials, we have a more detailed spreadsheet of our revenue and the sources of funding and all that broken down in more detail. But kind of at a high level, I wanted to take you through the funds that we have right now. So with our projection of that $20 million for 2020, the total funds that we'll have available for 2020 is about $75 million. So even if we did the no change option for 2020 of the $55.3 million, we still anticipate to have reserves of about $19.7 million at the end of 2020. So with that, and I think that was part of the Commission's calculus, is that the reserve is still a healthy amount, even with the no change option to have about $19.7 million left. The proposal that's on the table for the Board of Trustees is that for 2021, the grant distribution will be $23.5 million. And we project that even with the drop in IOLTA revenue, that we should have about $31.7 million in total funds available. And after we pay out the 2021 grant, our net assets at the end of 2021 will still be about $8.2 million, leaving a reasonable a reserve amount at the end of 2021. And the reason why we're able to still distribute very high numbers, even though IOLTA has dipped considerably, is because the interest rates the last few years have been high, and because we use that 4-step calculation that we described earlier, we're able to have build up a healthy reserve. At the end of 2019, when we closed out the year and had paid out all our grant and our obligation, our admin, we had about $50 million. So that really has buffered this drop for us. Banashe, do you want to add anything else to the slide? If not, I'll.
No, I want to be responsible with everyone's time. I know this has been a dense meeting. So if we could move to the 12th slide and final slide, please. As you can see, we've outlined for your consideration, your kind of consideration, the resolutions that we're recommending before you. I'd like to take your attention to number 3, the third resolution in particular. And I'd like to underscore a couple of items and make a plea and a request. In regards to this third motion, if changes to the equal access funds or other funding sources occur and impacting IOLTA funding grantees, the Commission respectfully is asking the board to delegate authority to us to determine whether increases or decreases to the 2020 and or 2021 IOLTA distributions are appropriate. There are other fundings and sources that are coming before us. Governor Newsom has approved the 2020 Budget Act on June the 29th. And the state's budget doesn't include a 5% reduction to EAF that was originally anticipated. It should be also important to note that that we have an additional $31 million that was recently approved for homelessness prevention as part of the redistribution of the 331 national mortgage settlement. And really the crux of this is, since there's going to be additional information coming and more funding can be changing. What we're asking for is that the Commission be granted the authority to respond timely and effectively. We're open, Dawn and I, to any questions that you may have. I'm guessing that Dawn will, with her expertise, be able to jump in and answer any of your questions, and I will do my best humbly as well. Thank you also for your consideration.
Thank you very much for your presentation, both of you. Does any member have any questions for either of our presenters?
Alan, if I could maybe say a couple things.
Yes, Chris.
Yeah, thank you. I just really want to thank Dawn and the chair for their really thoughtful meetings. It's a really pretty amazing commission. And I think, especially what's going on right now and the access to legal services and, you know, getting the funding in the hands of these organizations, I think is really crucial right now. I know I'm seeing it like every day where we work, folks needing help around, you know, rental, tenant protections, employment issues that are coming up because of COVID. So I think it's really important that these organizations have what they need. And I think the idea of having this carryover option is going to really help a lot of these organizations. But I just want to give credit to the chair and go on for all the work that they've done to move this forward. Thanks.
Thank you.
Any other? Deb.
Yes, go ahead.
Yeah, and I just want to echo what Chris has said. It has been a pleasure working with this committee. They're very passionate about what it is they do. And that's always good to see that people who are doing public's work have a real passion for it and a real concern for it. So I've enjoyed working with them and look forward to working with them even more in the future. So I don't know if I could talk, but I think I'll go ahead and like to move the item.
All right. Motion to adopt the recommended resolutions, all three of them, by Ms. Manning. Do we have a second?
I'll second. It's Chris.
Chris Iglesias, second. Thank you. Is there any further discussion? I also would like to take this opportunity to thank every member of the commission and the staff who works on it for not only their work over the years and all of the time and effort that they put into it, but especially in this very trying time, the extra attention and thought that you have given to the problem of the declining revenues and how best to deal with it while still trying to maintain the highest level of support for the legal service organizations. I think you've come to a very thoughtful and sensible conclusion. So thank you both for your long-term commitment and especially for your short-term work on this immediate problem. All right.
Thank you.
All right. May we have the roll call, please, Ms. Cohen?
Broughton.
Yes.
Chen.
Yes.
Cisneros.
Aye.
Dela Cruz. Dellen.
Yes.
Duran.
Yes.
Iglesias.
Yes.
LeBron.
Recused.
Manning.
Yes.
Portula.
Yes.
Selig.
Yes.
Stallings.
Yes.
Motion carries.
Thank you. And again, thank you for your presentation.
Thank you so much.
All right.
Thank you.
Thank you. Okay. Agenda item 704, Supreme Court/State Bar Blue Ribbon Commission on the Future of the Bar Examination. And I understand that Ms. Chavez will be presenting this.
Mr. Chair, this is Sonia Dellen.
Yes.
I would like to inform the board and the chair that I would like to recuse for potential personal conflict for 704 and 705.
All right.
Thank you.
Thank you.
Hi, good afternoon, everyone. This is Lisa Chavez. Can everyone see my screen?
Yes.
Yes, we can.
Okay, terrific. Thank you. Hi, good afternoon again. I'm Lisa Chavez. I'm the director of ARIA, the Office of Research and Institutional Accountability. At your board meeting in May, you directed staff to form a Blue Ribbon Commission for the future of the California Bar Exam in partnership with the California Supreme Court. This commission would take up larger, long-term policy issues pertaining to the bar exam, such as issues pertaining to content and format. This agenda item asks you to adopt a charter that will guide the commission's work and approve the proposed composition and size of the commission. Staff will work with the Supreme Court to finalize the charter and appoint the members. The proposed charter and the commission composition is an attachment A to the agenda item. So as a reminder, the background to this work is that the CAPA working group submitted its final report in May of 2020 of this year, and they looked at the results of the CAPA analysis and recommended that the California Bar Exam test for 8 legal topics and 6 skills. Also in May, you heard of the results of a series of studies that were either commissioned by the State Bar or conducted by the State Bar. And the National Conference of Bar Examiners will be issuing its final report on a job analysis that it's conducting this year. So the commission's chart is very straightforward. First, they are asked to review the CAPA study and the working group's recommendations, as well as other materials and studies relevant to the bar exam. And after they've conducted that review, they are to develop recommendations on whether and what changes to make to the bar exam and whether to adopt additional testing or tools. So to delve a little bit deeper into each of those, they'll ask the first question is, should California adopt the uniform bar exam? In particular, this is where they will look at the results of the CAPA analysis, look at the CAPA working group's recommendations, and look at the results of the NCBE study, and ask if there's sufficient alignment in between what California entry-level attorneys should know and be able to do versus what is going to be recommended for the UBE. If the commission recommends that California adopts the UBE, then the commission should recommend whether or not California should have some supplementary content and skills to be tested, and if so, how they should be tested. Another question they will be considering is whether California should revise the California Bar Exam. And in particular, they are to make recommendations with regards to the legal topics and skills to be tested, and then provide specifications for supplementary testing or training for topics recommended for inclusion on the exam and exclusion on the exam. They should also make recommendations for testing format, any changes there. And also they should review the passing score, review its appropriateness and whether it should be changed. So the composition of the commission will be 16 members that will be appointed by the Supreme Court. We're committed that this commission will reflect the state's demographic and geographic diversity in attorney practice sectors and settings. At least one will be a lawyer who took the bar exam within the last 3 years, and nominations will be drawn from the following entities and stakeholder categories. Here they are. And that's the number from each category. And the timeline is that this group will begin their work in fall of this year, 2020, and present a final report on its findings and recommendations no later than June 30th, 2022. That's all I have. Any questions?
Thank you very much. Any questions for Ms. Chavez? Right. Well, thank you for that very concise and informative presentation. I appreciate it.
Thank you. You're welcome.
Is there any discussion among the board? I do have one question, and this perhaps should go to Ms. Hershkowitz. We've heard comments by a number of people in the last few public comments that we've received, certainly with the applicants to the bar that occurred on July 7th, and even this morning, questioning the efficacy of a licensing exam in this format in the first place, which I suppose is the fundamental and threshold question, whether it's whether the answer may or may not be supposedly self-evident or not. I'm not sure, but would that inquiry come up within the charter as we understand it, Ms. Hershkowitz?
So I think that's a fabulous question, and I think that's something that could be teased out specifically in the charter, that the recommendations would address specifically. We can say sort of the whether a bar exam, we can figure out exactly how to wordsmith it, but whether whether a bar exam is the right tool to determine minimum competence for the practice of law. And then go after that, sort of go through the other questions. If the answer is yes, then you go through the other questions. If the answer is no, then you would develop other ways to test minimum competence. Lisa sort of gets into those other ways when she talks about if we, we should look at other supplementary testing or training for topics not on the bar, but that assumes that there is a bar exam. So I think we can build in that essential first question of whether the bar exam itself is the appropriate tool for testing minimum competence, and if not, then what would what should be administered in place of a traditional bar exam?
I think I would suggest that we may want to consider making that one of the topics that's specified, and perhaps topic number one, which is a consideration of whether a licensing examination in the manner in which we have traditionally presented it, whether it's remotely or in person or anything like that, putting that aside, but that type of test that we've been using is the best, most efficient and efficacious way to determine basic competency for entering attorneys in this day and age. So,
and I think that you could also add a tail onto that question. I think there are certainly those who would say that that the transition from an in-person bar exam to an online bar exam was something that was bound to happen at some point in the future. nobody expected to be in the position that we are right now with the pandemic. And so I think it's been forced on a lot of states so more quickly than they would have been ready for, but it's certainly a possibility that might be part of a licensing structure in the future. And so, so I think the consideration of whether a licensing exam is the best way to determine minimum competency should also question the modality of that. So whether that exam is administered in standardized testing centers or standardized testing venues or through a remote approach.
Okay, well, I probably be prepared to offer that language to that effect as a friendly amendment. So is there any further conversation or discussion about the resolutions as they are presented, or my meandering rumblings about a possible friendly amendment? All right, then, hearing no discussion, I would suggest that we have a motion to adopt as presented, and then I will try to work with Dag to come up with, or Donna to come up with some language on the fly to insert that as well, if we need it. That would be, although, no, I don't think we need it. I don't think we need it in the resolution. We just add it to the list of topics. Does that work?
Yeah, I think we would just say where it references in the first part of the resolution, it references attachment A. I would just say as amended.
Very good. Okay.
This is Jose. I'll make the motion.
Thank you. Moved by Mr. Cisneros. Second.
And Stallings, second.
Thank you, Mr. Stallings. Seconded by Mr. Stallings. And I assume that that's with the amendment as we've put it in there to attachment A. Is that correct?
Yes.
And
correct.
Okay, thank
Correct.
you. Any further discussion? All right, please call the roll.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Dellen is recused, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Bertula,
Yes.
Peleg,
Yes.
Stallings.
Yes.
The motion as amended carries.
Thank you. All right, the final agenda item on the open agenda is 705, consideration of issues related to the postponement of the July 2020 bar examination. And I understand that Ms. Hershkowitz is going to present on this, but I also understand that Mr. Stallings needs to recuse himself from this conversation. And Mr. Stallings, do you want to be removed from the room, so to speak, and head on over to the closed session, or do you want to stay here?
If I could be relegated to attendee, that way I'm stepping away from the table in a Zoom sense.
Very good. Please relegate Mr. Stallings to that place where he should go.
Mr. Chair,
Yes.
also I am recusing. Same way as Mr. Stallings.
Okay. Please transfer Ms. Dellen too, but be more gentle.
Who knows? It might be more fun where they're going.
Yeah. What are you saying? What are you implying? All right, 705. I believe, Donna, Ms. Hershkowitz, you're going to take this one on?
Yes, so I want to take this opportunity to provide an update to the Board of Trustees about the status of where we are on the decision making for the status of the bar exam, or more correctly, where the Supreme Court is. At the time that the agenda was developed and was posted, we were unsure if the court's final determination would have been issued, and if so, if it would have necessitated board action. If that were the case, then we would be talking about some specific board action at this time. The court has not yet issued its final determination, but its release is imminent. So at this time, I did want to provide a little update, and I might get some support from our chair or from Josh Pertula on this. But I just want to let you know sort of what's been happening and what could happen in the future. The State Bar has been working in close communication with the Supreme Court about the options that you have all heard and read about that have been emailed to you and presented to you, including the issues that were raised today by many of our public commenters. In balancing the needs of public protection and the significant, cannot state that enough, the significant impacts on law graduates and others who are trying to gain admission to the State Bar of California, we really have been looking very closely, and the court has been looking very closely at all of the issues that have been raised, the challenges with the many different options. Obviously, along with the applicants who you heard today during the public comment session, the bar and the court both would have liked to have made a final decision long ago. But with the changing conditions, including the limitations recently announced as to specific dates when an online exam can be held, and the need to thoughtfully consider the bar's mission and the reason for the current requirements related to admission to the practice of law, there is just simply no easy decision, and there is no perfect solution. Many states are actually making or revising decisions as we speak. In fact, just a few moments ago, the news came out that the state of New York just released its decision to cancel the September bar exam, having previously postponed that exam from July. And at this time, the state of New York has not announced alternate plans since they are not having a September exam. That's not to justify the fact that we don't have a final decision. It is to explain, however, that many states are finding themselves in the same place that California is, where we are really trying to evaluate what is the best thing to be done for the applicants who will be taking the test and for the public that we are charged to protect. Again, one of the things that I certainly want to make sure that we are clear about in all of our communications, I know all the board members know, the final decision on this does not belong to the bar. The final decision belongs to the Supreme Court. We have been working extremely close with them as this process has moved on. A couple of recent events, frankly, to talk about where we've been communicating closely with the Supreme Court. Back on July 2nd, 3 justices from the court, a few members of the Board of Trustees, a member of the Committee of Bar Examiners, and some staff here at the State Bar met with about 45 law school deans to get the input of the deans on the decision that the court had to make. The week after that, on July 9, so a week ago today, we held a webinar, a Zoom webinar with bar applicants. We notified everybody who'd registered for the bar, which at that time was about 10,500 applicants. Right now, that number is actually closer to 12,000. But we notified everybody about the meeting, and about 2,700 people showed up. We took comments from about 100 bar applicants at the time. The Chief Justice, Justice Cuellar, and Justice Liu were present for the meeting, as well as, again, several trustees and a member of the Committee of Bar Examiners and State Bar staff. And again, to hear the input of the applicants and the direction that they think is the way to go, and the challenges that they think are they would face, the challenges we would all face with any of the other options that are under consideration. As you've obviously heard today, a large percentage of the applicants favor a diploma privilege, and we're very clear with the bar and the court on the challenges that they believe would exist with an online exam or an in-person exam or anything short of the diploma privilege option. I would like to note that there is, and understandably so, a fair amount of confusion and misinformation out in the public sphere about what an online exam is, as to the requirements, the impacts of internet instability, the tools available to use in a remote administration, etc. Amy Nunez had tried to allay some of those concerns in some of the meetings that we had with the deans and the applicants. I know that Alan talked a little bit about some of that today, talked about the AI and the concerns that people have about AI and the biased algorithms that are built in. trying to assure folks that the AI is just the first sort of round that is identifying possible issues, and then there are several layers of human review that follow the AI. But because there is so much misinformation and confusion, if the Supreme Court were to direct the administration of the exam happen remotely in an online manner, we are prepared in short order to issue an FAQ to help folks understand what the exam would be like, what those challenges are, what the issues with internet connectivity are, why an MBE would be provided, et cetera, sort of the questions that we've been hearing that we hope, again, should this be a direction that the court recommends, we would like to allay fears if that is something that is needed for us to do. Again, I do expect a decision from the court imminently. Because we don't know what that determination is, and Sarah, at this point, if you could sort of post the resolution, because we don't know what the determination of the court might be, and I expect that there is going to be some real need for the board to be able to act swiftly and decisively. I just, while we were sitting here, threw together some language that I'd like for the board to consider that would provide us some resources, board resources and board oversight immediately. And so you see what we're proposing is that Josh Pertula would work with staff on efforts related to an online bar exam, should there be one, and Helen Chen to lead implementation efforts related to any other direction that the Supreme Court may provide. And then you see the further resolve that that the board would delegate to Helen Chen the authority to appoint a working group or take other steps that are necessary to implement the direction of the Supreme Court. The reason, just so you know, that we divided this out between two folks is Josh has been working in this capacity with staff in the initial run up to the baby bar and sort of where we are today in terms of the decision making on the exam, and he's developed some real expertise on that, and I would love to continue to have his eyes and his thoughts and those that he has pulled together to help with thinking through that. But we know, you know, that I want to make sure that if I'm looking at multiple things, that I'm not spreading Josh too thin, and that we'll be able to have a good division of labor if there are multiple options that we need to be examining and doing so quickly.
All right, any questions for Donna? Josh, do you have any comments you'd like to make?
Yeah, no questions, but a couple of things. One, folks, this is, as everybody knows, and they could hear from the public and the applicants earlier, is a really complex issue. One in which, although it might not always seem to everybody, but the staff has taken, not ignored a single issue, not an email, not a phone call, not a request, not a public comment. It's been analyzed, it's been considered. It's a tremendously difficult time for a lot of individuals, and that's recognized. And we've tried to get the bar I've watched, try to get the information to the court in a timely fashion, and the court to make a decision. And as Donna said, we're eagerly awaiting and looking for a direction. What I would really like to say, Alan, is the amount of work and the amount of dedication that Amy and the admission staff has put into this has been incredible. Long days and weekends and nights, and I commend them for it. I think everybody is moving in trying to do the right thing here, and it's very much appreciated on behalf of the Board of Trustees. I thank them.
Thank you. Yeah, I'd like to follow up on a couple of things that both Donna and Josh have said. First of all, Amy and her entire group have been working extremely hard, as we've heard, but just to give you a real example, over the 4th of July weekend, we had people working in order to get a certain project done. So people are rolling up their sleeves and really pitching in. Second thing, and from the staff especially. Second thing, I do want to thank very much, Josh, for volunteering to head up this working group of people that Donna appointed to put extra eyes on the entire process and get more board involvement. And along with Josh, Chris Iglesias and Mark Broughton have been attending these meetings and participating and been tremendous. So I want to take my my hat off to both of them as well. And Sean and I have been kind of ex officio hanging on, but the meat of the work has been done by Josh and his group. We don't know which direction the Supreme Court is going to go or what they may ask us to do. So what we have done is, and as Donna is recommending, is putting in place a placeholder committee headed by Highland that needs to be fleshed out once we find out what direction we're going. But it will be, if there is anything that they want us to look at, there will be tremendous time pressure and a lot of work to be done, and our resources are getting very stretched within the bar itself. So this will be a difficult task. Of course, we've got a great person to lead it in Highland, and any of you to whom she reaches out for help on that committee, I would certainly encourage you and hope that you would find your way clear to help her. I know we have people, every one of you is working on various liaisons or working groups or this, that, or the other thing, in addition to just trying to keep up with all of the agenda items and understand all that's going on. But it is a critical time between now and this fall. And unfortunately, we're in a position where great things are required of this particular board. But I do want to thank each and every one of you for that. So unless there's any other comments or discussion, we should go back, I think, to the resolutions. Yes, Renee?
Yeah, I'm just curious why we haven't made it more clear to the audience that this is a Supreme Court decision. I felt today, I mean, I understand like the amount of angst and emotion. It just,
well, I understand, and I understand your point, and it certainly comes across from the people who do speak and make their public comments that there is a lot of confusion out there. I will say that in every meeting that I've been in with the public, it has been made abundantly clear that the final authority here is the Supreme Court, and they will be the ones who will make the decisions. And I think that the leaders of some of these groups understand that, but I think somewhere as this information gets passed around, that gets lost. And since it's the state bar that's actually administering the test, we're the ones who seem to be deemed responsible for all of the decisions, not just the administration of the test.
yeah, I thought maybe I was.
Yeah, you haven't missed anything.
Alan, if I may, just for Renee, I'd like to add that although obviously there are a lot of people affected and a lot that want to comment and want their point of view to be heard, it's not just the bar. They are also, and I can tell you, I know firsthand, advocating and voicing their opinion to the court also. So they do understand that.
Okay, thank you.
Yeah, thank you, Josh. That's a good point. Okay, any other comments or questions? All right, then let's return to the resolutions, please. And the chair will entertain a motion to adopt as presented.
It's Josh Pertula.
Josh Pertula moves.
Moved. Yep. With motion.
This is Jose. I'll second.
And Jose Cisneros second. Any further discussion? Okay, please call the roll, Ms. Cohen.
Broughton,
Yes.
Chen,
Yes.
Cisneros,
Aye.
De La Cruz, Dellin is recused, Duran,
Yes.
Iglesias,
Yes.
LeBron,
Yes.
Manning,
Yes.
Pertula,
Yes.
Selig,
Yes.
Trustee Stallings' recusal is noted. The motion carries.
Thank you. All right, would you please bring back Mr. Stallings and Ms. Dellen from their self-imposed exile? I'd like everybody to hang on for just a moment, but while they're reappearing, welcome back, Brandon. You have on your able to access your new link in for the closed session. And for the anyone who is interested, we'll be going into closed session in just a few minutes. We expect that will take 30 to 45 minutes. I will come back out and report or close the open session. But before we do that, it is now public because Donna made it so this morning in her remarks. But this may be the last of the Board of Trustees that at which she serves as the interim executive director. I'm sorry to see that she is not in the running, not put in her application to become the permanent ED. I want to give her a tremendous amount of credit for having for the programs department, if you will, and just getting that going and having new people in there and then being abruptly elevated to interim executive director really needed to keep a very close eye on the programs portion of her work, because there wasn't anybody who was really qualified to take over lock, stock, and barrel for her. So she's really been running two almost full-time jobs during this period of time since late last year. And she has done a terrific job. It has not only been, it would have been daunting if it had been just the two jobs combined, but on top of all the remote working and the changing of the bar exam and all of the issues that have arisen this spring, I think it's a credit to her, the fine shape that we are in and that we have come as far as we have. So please join me. I'm going to stand just so she has a standing ovation, but I want, please join me in thanking and applauding Donna.
Thank you, Donna. You've done a tremendous job.
Thank you.
Thank you, Donna. All right. Let us now go into closed session pursuant to Government Code sections 11126 through 11126.2. You there as quickly as you can make it. Thank you. Now, do we need to take roll?
Not It is my understanding that we do not.
Okay. All right, then in the closed meeting, we discussed various matters of litigation. We are now through with the open and closed sessions of today's Board of Trustees meeting at 3:59 p.m. in the meeting. Thank you all.
See you tomorrow.
All right, bye-bye.
Thanks, Phil.
Good evening, everyone.